Permission for moving a urgent petition today or tomorrow? Urgency,
As you wish. I have no problem
2 p.m. 2 p.m.
today.
I mentioned WPC 1165 for withdrawal lordship. Very urgent situation.
When you are tomorrow.
May I please, your lordship, my lord? In item number 6, lordship, we have filed an affidavit in opposition. Item number 6, lordship. That record may be called for, lordship. Deeply obliged, lordship.
Admission lordship. We need to complete in this case.
What is the urgency?
Please, the construction of saloon house of the petitioner.
Huh?
Police interfere with the construction of saloon house of the petitioner. Petitioner is.
Police is interfering. If it is police atrocities, I think you have to go before the DB1, isn't it? Hmm? Police atrocities is DB. Yes? Action এখন notice করো সব। Police atrocities is DB. No, DB1, police. এখন সব রস্তর এখন যে থাকে, আমার নোটিশ করে ইস্যু করে। Just come up for motion. Admission. Okay. Why do you need it before vacation?
Saloon house is one source of livelihood of the
Huh?
petitioner. Petitioner is barber or professional house. If saloon house is already.
We got an interim order, no. Okay, after vacation. We'll have it. Okay, try our luck on 19th. 19th, let's see.
My lord, I beg to mention WBC number 4107/2025. Notice was issued and the respondent has also filed the affidavit, my lord. My lord, before vacation, may I pray for a date? my
Matter
lord?
pertains to,
Pertaining to settlement of fishery, my lord. Fishery, my lord, the matter also pertaining to, my lord, outstanding revenue, my lord. So we also prayed in the writ petition for remission. And some financial problem, my lord, he could not benefit it, my lord. So
difficult.
any
I
convenient,
have it after vacation.
convenient date, my lord.
Hmm?
Date may be fixed, my lord.
Fifth, reopening.
Reopen.
Need please, your lordship, because this matter has become infructuous. Matter pertaining to promotion to the post of administrative official judicial law. Matter was pertaining to the promotion to the matter of administrative officer lordship, judicial law. Petitioner put to challenge the notification by which lordship G junior junior employees with respect to the comparison to the petitioner.
You have retired.
No, lordship, now he's serving as administrative officer of judicial.
So it has become infractions.
Already he is
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the writ petition has become infructuous. Mr. T.J. Mohanty, the learned senior standing counsel, assisted by so-and-so, appears on behalf of the Guwahati High Court. Taking into account the above, the petition stands closed.
Okay.
Additional office is working as a sweeper office. Therefore, in the establishment of the region, her appointment was 3/90/2011. In this declaration, I am claiming regularization and scale of pay attached to the post of sweeper. And in terms of the honorable court's order, I have also filed an additional petition, bringing on record the recent judgment of the Supreme Court.
What additional affidavit?
Dharam Singh, Sripal. Lordship, may kindly take my additional evidence.
Matter for promotion.
One more judgment lordship, Jaggo lordship, one more judgment, Jaggo lordship, same thing. Jaggo lordship,
कुछ भी हो सकता है finance
Yes,
finance is finance department was supposed to file the response.
they are no such thing. They are-
finance is a party.
Finance
Yes,
department, they only produced the office memorandum, but that office memorandum was issued subsequent to my account.
That is not material. Tell me, did you have a right to regularization on the date on which you were appointed?
Oh.
Eh?
But I-
You claim that your right has accrued, taking into account that the authority also wants your services, not your services, the service of a permanent worker in the establishment of a sweeper. So there is a requirement. So therefore, you should be regularized, or that post has to be filled up by giving you an opportunity for participation. That's all.
That is how lordship, they have worked on 3 occasions lordship to create 3 permanent posts of gardener and sweeper. For the registry of the Guwahati High Court lordship. Creation of posts, they have some communication lordship, I have lordship.
But the problem arises whether such creation of posts can happen when there is an office memorandum. Therefore, I said, whether are you
Has to be
going to
challenged.
challenge that office memorandum or
Exactly.
not? Because it's a policy decision.
But immediately lordship, I was appointed prior to the issuance of the office memorandum. So whether it should.
Would
be-
you have a right for regularization on the basis of your appointment? If it is so, then this very proposition of law which you are submitting may be correct. But as on that date, you did not have a right to regularization. Because you have to understand, when you were appointed, it was not appointed to a government service by following a procedure.
It was because of the exigency of service lordship. because
So
the-
therefore, as per the exigency of service, you have gone for it. There's no quarrel with that. You were appointed, but that doesn't mean that you have a right for being brought within the ambit of the post of the government without following, because otherwise it is going to violate Article 16. There are many other people who may have come. So at the best is, see, you were appointed, these are appointment post Uma Devi, isn't it? You were appointed in 2011. Well, Dharam Singh, all these judgments are prior to that. Dharam Singh is of a case of 1998-99, isn't it?
yes.
What do you say?
But my understanding is that when the lordship on the last occasion also lordship expressed this view that this office
Express
member.
many views.
No,
The
it is-
fact that whether that view I will hold is
No, no,
another
I'm not saying your lordship will hold, but this was a part of the discussion regarding this office memorandum, my lord. That you have to challenge this office memorandum because there is a clear provision in the.
Otherwise, what the problem is this. I can't direct creation of a post. that is a bar in view of Uma Devi. I can't direct creation of a post because the creation of the post is absolutely within the domain of the High Court with the state. And more particularly in the case of a district establishment, the creation of post then also depends under the directions of the High Court on the administrative side with that of the state. Now the state has an office memorandum categorical that there shall be no creation of post for sweeper.
Exactly.
So when I granted you the liberty, why are you not challenging it?
The Dharam Singh Lordship is a very recent judgment. It is on August 19, 2025. Much after Uma Devi Lordship.
No, হেৰি কৈছে মানুহবিলাক এপইণ্টমেণ্ট হৈছিল prior to
Those persons were appointed in the year 1998-99. There
Oh.
was a scheme out there. And those people were taken out. I have no problem in directing them to give you an appointment, regularize you. I have no problem in giving it. But the problem arises is that order cannot be complied with. And I would not like to pass an order to that effect. An order which is to be complied can be complied with. Because if I ask the state, the first thing they have filed, there cannot be a direction for creation of a post. That is a policy decision. Whether that policy decision is right or wrong is another aspect. In fact, I am in your favor to that effect that I also want that this office memorandum should not have come into the being in respect to the establishment of the state, of more particularly the courts, because the post of the sweeper is as essential as that of the district judge. Because without the sweeper, the High Court or even any court establishment cannot run. There's no quarrel with that proposition. There's no quarrel. But the only thing is, how do you take care of that office memorandum? You have to give me some handle. Don't you think so?
You may kindly consider my second prayer. Also.
What prayer? Minimum.
I should be paid the scale of the attached to the post of grade for post.
And again, another thing is different because that was done as per Upen Nath. Upen Nath's judgment, it was a consensus judgment. Now, as per Jagjit Singh, if you want, I should give you, as per Jagjit Singh. Yes, I understand. But you have to also understand that pursuant to Jagjit Singh, there is another judgment of the Bihar farm owners or something, wherein the Supreme Court says that to give the equal pay for equal work, you have to look into many other factors as to how the person was brought within the field. That is 2019-18 SCC.
Yeah.
There they are saying about Jagjit Singh.
That case also may grant me some time also I will work for the best.
Yes, Mr. Das. You see,
That's
one
true.
thing one has to understand. How the High Court works, how the District Court functions. The Constitution has categorically made it in such a manner that they are brought outside the fold of the executive.
Correct.
Executive interference is the least as per the Constitution.
Yes.
It's a different thing. Whether it is happening in practical field, it is happening, it's a different
Fine,
field.
fine.
But
Hmm.
to have an independent judiciary,
Correct.
which is also a basic feature of the Constitution. Therefore, the question as to if for the purpose of establishment of the for a particular establishment to run, can it be based upon the decision of the executive that we are not going to create a post for the sweepers?
Yes.
taking into account that the High Court as well as the District Court, the judiciary is outside the scope. Yes, they may make rules, but that rules is again with the concurrence.
Yes.
Now, the Supreme Court had again mentioned that it is not a mere consultation. The concurrence of the High Court is has to be given more primacy than the concurrence of the Union Public Service Commission or the Public Service Commission, which is mentioned in 235,
235.
235.
235.
So, therefore, in that context, can it on the basis of the executive instruction, it's an executive instruction,
Give instruction.
take away the power of the High Court under 235
Yes.
for the purpose of managing the establishment of the district judiciary as well as the High Court? Because we are having a big problem.
Correct.
You may not get in many places, like out here, you are getting the Sulabh.
Outsourcing, it's not possible in
That outsourcing you may not get there. Can you say, in view of Dharam Singh, or even in as per Kirpal and all, Sirpal and all this thing, that their services can be dispensed with? No.
No.
So they are necessary.
Correct.
Well, don't you think that the High Court should also come up with an affidavit to the additional affidavit file and reply to that? Come up with that, something to that effect. So that give me some handle, because this is
Yes.
something which is required. Outsourcing is okay where it is possible, but where it is not possible to outsource, like in a
But-
place like Gosaingaon, it's not possible to outsource. You would not get anybody. Then how do you take care of a situation there? You have to give somebody an appointment. Now, this appointment is going on for a long period. Now, if you have a permanent post, I'm not saying that it is a case of regularization. No, I am against this regularization concept. Here, the petitioner, you have to create a post where the petitioner can be given some scope for purpose of participation in that selection process, so that Article 14 and 16 is duly followed.
yes.
Thereby, obviously, the petitioner has to be given some, because for the last so many
Waiting.
years, the petitioner have worked, so something can be done in that regard.
Yes, yes, that is fair.
But as regards the creation of the post, that's, I think, is essential, more particularly. You
Need
cannot
of-
think to
actually
that
need
effect.
of the hour.
It's the need
It's
of
a
the
need of the hour, my lord.
one cannot do so, and therefore one has to also think how it can be done. We'll take it up with the finance. In this matter only, I'll take it up with the finance.
Yes.
You see, the only thing is this court cannot direct regularization, but this court can very well direct for consideration of the case of the petitioner along with others upon creation of the post.
Yes.
However, giving some relaxation, taking into account that the petitioner has worked so and so, and the age relaxation.
Yes.
I think that would be a fair order which can be passed. But we need
post-
something to that effect.
Post has to be there. Post has to be there, and finance has to take a call with regard to this sweeper.
That is why I asked him to challenge it.
Exactly.
He's not challenging it. Problem arises there, na? You have to give me some handle. Where do I where is my handle? They will come up and say that this is not a part of the challenge also.
Correct, my lord.
Get the point, Mr. Das.
I'll discuss.
Do some public service. I understand your client may not have the resources to pay you the material consideration for filing another case. But do something for the good.
Yes.
Then things we can do something with that as regard them. That non-creation of posts, because you challenge it. What am I mentioning? Bring these as highlight these. That office memorandum is there. That is okay. Let it be there. But they cannot come in the way of the judiciary.
Correct, my lord.
Come up with that. Let it be there. But will it come within the ambit? Because that means they are controlling the creation of the post as to how the establishment is to be run, which affects the independence of the judiciary and thereby the basic structure. Come up with that. I can't give you more advice. Don't you think so?
Kindly adjourn.
I gave you therefore. Then we'll have the finance there and then take it up with the finance.
Let them do whatever they do with their department. So far as district judiciary is concerned, it's unmanageable without this super.
Absolutely, it
in-
is unmanageable. Then I can take the help of the Jago, Tirpal. It's not a case of regularization. It's the case of creation of post.
Hmm.
You see, the most pertinent aspect of Dharam Singh is not the court did not go into the question of whether the court has the power to direct regularization. It went into the question
necessary.
as to whether the non-creation of a post was justified, and that aspect is subject to judicial review.
Hmm.
Thereupon directed the employer to look into it. You have not created the post. So once you have created the post now, these people have been working. You had the scheme of 1998-99. So without a scheme also, there cannot be a direction. When you have a scheme, then the question of arbitrariness, unfair labor practice, all these things comes into the being. So therefore, you have to understand Dharam Singh in that light.
Yes.
So your basic is to trust on the creation of the post. And then, if God permits, you may get it.
I will attach my client.
Chala? Let's have it. An additional affidavit has been filed by the petitioner on 3/11/2025. Mr. H.K. Das, the learned counsel, appearing on behalf of the Guwahati High Court, submits that he would obtain instructions in that regard and, if necessary, file an affidavit, file a rejoinder to the said additional affidavit. Mr. S.K. Das, the learned counsel, appearing on behalf of the petitioner, further submits that the petitioner had been advised to file another writ petition challenging the office memorandum. And as such, the matter may also be adjourned. Lists this matter on 22nd of January 2025. In the meantime, the rejoinder be filed on or before. Let's have it on 29th, on 22nd of January.
Fine.
As with the last order, the representation was to be placed before the authority. Coming.
Lord, my instruction is that still the representation has not been submitted by the association. The representation by the association is yet to be submitted. They haven't submitted the representation.
It's already on record, Raj.
Huh?
This representation is already on record, Raj. 28/3/2023.
28?
Record.
No.
No, that you see, no, you have not understood. The representations so submitted on 28/3/2023 be placed before the said committee so that the said
No,
representative
after
would
the-
aid in the deliberation.
I understand, my lord. After this, my lord, I'll just place these instructions, my lord. Guwahati High Court Employees Association, my lord, they took 4 weeks time to file the representation. That representation is awaited. Wait. In November, আহিছে তাৰমানে তহঁতৰ representation খন আছে হা. Then the meeting was held. Then association took time to file yes, detailed representation. That is forthcoming.
You are what?
Stenographers, my lord, read.
Are you not a part of the employees association?
Yeah, otherwise the part.
Then why you are not raising that?
Yes.
My instruction was not that, because I was only apprehending that 23 will be placed, and that is also a part of the record, so that it has been placed. But
It's
the
okay,
employees
but
association was
they have been asked
Lord,
If you are part of that, why you are not raising that?
What's if I'll have that instruction with these?
Hmm?
Will I have this instruction, but whether they have gone with the employees association or not, because 23 otherwise was placed before the authorities. That was already what I've.
No, it's the, it's.
This is for the service rule, na?
Service rule, 7-3 lodge. Rule 7.
Any idea when the meeting is there? I'm also there in that room.
Yes,
I
Nick,
don't know.
because,
I'm not,
uh,
I was not there.
Well,
in 19.
it says that after the representation is submitted by the association, the meeting will be held, my lord.
Take it up,
So they should,
take it up with the High Court Association
Definitely.
and submit your representation. Or do you want to submit separately?
Well, I didn't have the instruction. As of now, I didn't have the instruction. But I was only represented that 23 has to be placed. That what I have instructed them that to place. And that is on record. But I have instruction that as regards the employees association, they will go with that.
You want to go with the employees?
But I'll just have instruction whether they want to proceed with that or they wanted that.
Have the instruction in 15 minutes, we'll
Look,
finish it.
at 15.
On the administrative side, I can very well look into it. I will be looking into it because I am a part of that committee. We'll look into that. There's no quarrel with that. So here you just find out whether you want to give it independently or yeah. But I think it should be given by the association. It will have more force.
Collective. I do
Well,
understand.
what is your grievance?
Well, that 7-2A, the 2AA, double A, that goes, senior grade. That gives us stagnation of 19-20 years. That
Hmm?
is- Stagnation is my issue, brother.
The senior stenographer doesn't have a avenue to go to become a Eastern register also. That I understand. So I think follow it with them. Or if not, otherwise you
I
give it
think-
by yourself. Give it as soon as possible because otherwise it's just delaying it. We want also to make a necessary amendment to the rules. The rules are in a very bad shape. So if it happens,
Rules
The
are.
rules
I shouldn't have, but these are, that stagnation period is too long. That is the.
I was actually waiting for one writ petition from the court masters. The reason is this. You don't have a feeder post to the AOJ. If you see that, only mention is there in a proviso to Rule 7.5 that a court master would become the AOJ. But what the High Court in reality is doing, reverting the court master from AOJ, from court master to
SJ,
SJ, and then promoting him to the AG.
because of that rider.
It reminds me of a story sometime in Ramayana and all, where you never used to do it straight away. It used to just turn around and then come to that particular point where they can then draw a straight line.
Absolutely. The 2A actually is not in 7-3. That is one more aspect. In 7-3, the promotional post, they say that 2A is not there. From 2A, 2AA is not there. 2A, then assistant register, but 2A has been brought. So, there. the
Now, understood. No,
stagnation
there is no quarrel with that.
Correct.
And I'm absolutely in agreement. But the question is, as the High Court committee is looking into it, I thought that it would be better for you to submit a representation. And if you submit that, High Court committee will look into it. Therefore, I ask you whether you'd like to submit a representation that High Court committee will look into it. Submit it before vacation. When is the next date? No idea, na? So they
No,
will
no.
consider. So
They can pursue with the association members and then expedite the thing, my lord. Because their individual representation is already there. So association representation, they can pursue since they are the member of the association. It can
You see,
be,
there are many aspects. You take the case of a court master. How many court masters will be there? Take the case of an SJ. On the question of democracy, taking democracy into the side, their court masters may have a lesser bargaining power. That put thing. we should be actually being made the AOJ, not the SJ. They may like to, but the association as a whole may not like to put it. Here is a case where 2A, all people from 2A can become an extinguisher. Okay. And more particularly after my judgment out there, the court masters, the court officers, now the protocol officers also, everybody now will become an. However, a stenographer who is in 2A,
Senior gets stenographer.
he would very much be also considered for a assistant register. But as person who is senior to him, he cannot be considered for assistant register. Take the instance of a librarian. An assistant librarian can become an assistant register, but a librarian cannot. Can there be any more thing more laughable than this? So once you get a promotion to become a librarian, then you can't be an assistant register, which is a higher post. But if you are not getting a promotion, then you can jump your higher post and then become a.
No, this decision to change the rule was taken 2 years back.
No, the reason is the problem is there. Here you have assistant librarians,
Yes.
but in Mizoram you have librarian. So the Mizoram librarian, he cannot be an assistant register. All these things I've looked into it. These are the lot of flaws out there by which a courtmaster who is from JA is promoted to the post of courtmaster by way of a slip. This amendment was brought in. If you see 7.5, that particular person, however, can become a AOJ by taking his seniority as an SJ, but he has never been promoted to an SJ.
Hmm.
So you take a call in 15 minutes whether you want to
have it.
sail with them or get swayed by your own emotions and file by yourself.
I'll do that.
Mahendra Financial. What is this financial business? Taking into account the legal issue of fixes for final disposal on demand on which the year portable. No instruction from the company to the lawyer concerned to enter into any making. Oh, yes.
Well, I got a citation whether an advocate can compromise on. An advocate cannot compromise, there is Prashanta Kumar Sahu and others, but with Sarulata Sahu and others.
Supreme Court. You see, Mr. Counsel, the issue involved is of very big importance, taking into account what actually happens in the local adults.
Yes, Lordship.
Specifically, page, it starts from page 35,
Page?
page 35, paragraph number 100. It starts from page number 30.
Para 90, 100.
100.
Third question that arises for consideration in context with the legality and validity of the settlement in which the learned advocates appeared for the cross-objector, that is, defendant could have signed a compromise petition without the express consent. It is imperative duty of the court to ascertain the genuineness and lawfulness of the indisputably in the case on hand. The first appellant had neither recorded the statement of the parties in the court nor have any inquiry with the side. The High Court in its impugn had observed that the compromise petition was signed by the advocates without the express authority or without special wakalatnama executed in favor of the advocate. In fact, the authority was expressly curtailed in the compromise deed. In the aforesaid, we may refer the decision of this court to the case of Himalayan Cooperative Society versus so and so. The authority agency status affords the lawyer to act for the client on the subject matter of the retainer. One of the most basic principles of lawyer-client is the lawyer owes fiduciary duty to the client. As part of their duties, lawyers assume all traditional duties that agents owe to their principal and thus have to respect the client's autonomy to make a minimum. Thus, according to generally accepted notions of professional responsibility, lawyers should follow the client's will rather than substitute the judgment for their will. The law is now settled that a lawyer must be specifically authorized to settle and compromise a claim that merely on the basis of his employment he has no implied or ostensible authority to bind his client to a contract. With a lawyer by virtue of the retention has the authority to choose the means for achieving the client's legal goal, while the client has the right to decide on what goal will. Question here clearly begins. Rupesh shall at all times enforce himself in a manner befitting his status as an officer of the British Metropolitan Agency.
Lordship. May I submit, Lordship? And the defendant submitted the judgment, Lordship. Whether the situation of the judgment and my situation, the situation in this case, Lordship, whether it is similar or not, Lordship, kindly ascertain this fact, Lordship. I think, Lordship, this is not similar, Lordship. Because, Lordship, in that case, they might have, Lordship, approached at the first instance, Lordship, while the award was passed, Lordship. But in my case, Lordship, they first, Lordship, prior to the coming to the High Court, Lordship, they challenged this award twice, Lordship, before two applications, Lordship. That's maybe
No,
still kindly,
Mr. Counsel, my question is,
Lordship,
on the day
Lordship.
on which the local adalat was held,
Yes.
whether the council had the authority. I
Lordship,
am not on the question of ratification. Did he have the authority to sign?
Lordship, then Lordship, that council may be hard, Lordship. Others, that council, Lordship, he can say, Lordship, whether how much authority he has, Lordship, at that time, Lordship. Otherwise, Lordship, the telephonic discussion was there with the party.
Telephonic
Yes.
discussion cannot be a ground for settlement.
So, otherwise, Lordship, how the learned council, he's done this everything, Lordship, I do not know, Lordship. That's why, Lordship, his presence are all, Lordship, whether the bar
It's a
council.
different thing. The matter will go there. It will be heard. The appeal will be heard. It's in
That is
appeal
correct,
stage.
but
no?
Lordship, see, Lordship, my condition is there, Lordship, my vehicle was taken by.
That's
the-
a different thing.
in
You may have a good
2015.
case, you may not have a good case. All these
Now,
things are,
Lordship,
I'm not touching on the merit
yes,
as regards this, but I think this is a case for setting aside this, because what is happening is absolutely wrong. And all procedures, and therefore I normally always say in the local adalat, I always tell the counsel who sometimes says, "Na, I want to withdraw." Even you find out here always there are a senior says that okay, go and mention that I want to withdraw. I don't permit them to withdraw.
Lordship, then I cannot say, Lordship, whether that council has authority or not, Lordship, I cannot say.
Now you cannot say,
Yes, that
but the
will not-
fact that it is for the duty of the court.
Yes,
I'm saying I'm not saying it is your fault.
that is,
It is the duty of the court to look into it, that there was an authorization for him to sign on behalf of that. Advocate may very well sign. There's no quarrel, but he has to have a specific authorization because it is beyond the realms of his appointment.
that,
You have to understand
that
that.
is their Lordship, yes, Lordship, but in this situation, Lordship, I am saying, Lordship, what my submission is that, Lordship, the council, Lordship, he can only say that whether he has the authority or not, Lordship. Because still we're in.
No, did the court look into that? That there was an authority placed? My question is that he signed it.
Yes, he signed.
The question is whether on records there were that authority. My question is that
Yes,
you were present
yes,
on that day. I'm asking you.
yes, Lordship.
Forget about that, whether he had the authority. Did he place an authority on the records? My question is that. When you were present, you must be knowing that. Normally, if you see in the local alerts, there is specific authorization given that this person we are authorizing on behalf of the insurance company or in this company, he is to sign on in this matter or these matters. Don't you see it in the local alerts how it works?
Yes. But Lordship,
When I started, if initially when you become a new judge, the second local adalat bench is normally being taken as a new judge. So when I was given that local adalat bench, I said that initially they said that all these things without parties can be. I said nothing doing. Without the parties being present, I'm not going to do it. Maybe my reason for which I said that no, this led to I have never sat in local adalat thereafter. But the fact is this is an issue which needs to be tackled with a very strong hand.
now Lordship, another
This is an
question.
issue which needs to be spoken in all when new lawyers come and join the profession. That this is what is required of a lawyer. That he cannot act. His terms of appointment is, as per the Advocates Act, the Bar Council rules, which says that he has to act in the best interest of the client.
Yes, Lordship.
Now the question is that here in this case, they are trying to get the ex parte order set aside and get a hearing on merits in the original proceedings. That is their case.
Yes, Lordship.
He comes up and says that there is a compromise and we are agreeable to this amount. The lawyer says, on the basis of which it is being signed. Now, whether the lawyer has been informed or not, that is a different thing. But the lawyer was, as per his engagement, was not permitted unless there is a special engagement. That look here, you are specially engaged to enter into a compromise at rupees so and so. Where is that?
That's why I'm saying, Lordship, whether if the council come or whether the bar council.
Whether the council comes is not the matter.
He has
No, Mr. Council, whether that council comes or not comes doesn't matter. What is more pertinent is whether he has produced that authorization to settle at rupees so and so before the authority, before the local adalat authority, and that local adalat authority thereupon have, on the basis of that, permitted the lawyer to sign.
Lordship, then record
is
may
the
be,
issue.
yes, Lordship, then the record of the. Lordship,
Shala, we
yes,
call for the records.
Lordship.
This court duly heard the learned counsels appearing on behalf of the parties. Mr. U. Borman, the learned counsel appearing on behalf of the petitioner, have referred to the judgment of the Supreme Court in the case of Prasanta Kumar Sahu and others versus Sorulata Sahu, reported in 2023 9 SCC 641, and submitted that the issue which was framed by this court, the question which were formulated by this court in the order dated 19/11/2025 is covered by the said judgment. Pusto. Per contra, Mr. S. Hawk, appearing on behalf of the respondent, submitted that the counsel who entered into the compromise, compromise on behalf of the petitioner, is required to be asked as to whether such authority was given or not. In the opinion of this court, taking into account the judgment of the Supreme Court in the case of Prasanta Kumar Sahu Supra, the said cannot be the issue. What can be the issue at best is as to whether the counsel who appeared on behalf of the petitioner before the Lok Adalat and signed into the said compromise was authorized in writing to by the petitioner, and that authority was placed before the Lok Adalat, before the Lok Adalat, thereby the Lok Adalat permitting the said counsel to sign on behalf of the petitioner. For that purpose, it is the opinion of this court the records would be necessary. Accordingly, list this matter again on 9th of January 2026. 8th of January 2026. Full stop. The records of, what is the record?
Lordship, it will be FA number will be FL
Record of
state convert
epic is FA number
76 of
76/2018.
18, yes.
Pending before the Assam State Consumer Disputes Redressal Commission be placed before this court.
Lordship.
The registry shall take due steps in that regard. Interim order passed earlier shall continue till the next. Hey, it got a printer like for Dokari.
If I have worked with the people, but they say that already this representation covers the aspect which we have raised in the writ petition. Even if it goes individually and as it is taken,
Huh?
even if it is taken as it has been submitted, it would serve the purpose. Rather than going with the association again,
So you submit a fresh representation.
fresh number, I'll look fresh.
Mr.
Milord, one aspect, I just like to point out, Milord, perhaps it is not written in my instruction. Their prayer is, one of the prayer is that to change the quota,
Refixation of ratio.
refixation of the ratio, ministerial and stenographer stream, Milord. So perhaps in that context, the association, it may be in the form of a reply, subject to correction, but it's not written in the instruction.
You see, I am not deciding this aspect here.
No, I'm not saying that.
No, they say they want a quota.
Increase of the quota.
Obviously, they
So
need
it may have
they
the-
have a quota, but by which I think it is 4:1 or
4:1.
4:1. So they need more.
I will say.
So this I dealt it in that Islam's matter also, how it is to be done, how the stenographer, they have a quota and all these things I've dealt with. Anyway, so therefore, you want to submit a fresh, you submit a fresh representation into the committee, and the committee will proceed with that.
First.
And we'll look into that independently of the representation to be submitted by the Guwahati High Court Employees Association. First. Mr. H. Betala, the learned counsel appearing on behalf of the petitioner, submits Today, the writ petition has been fixed pursuant to the order passed by this court on 11/9/2025. This court inquired with Mr. H.K. Das, the learned standing counsel of the Guwahati High Court, as to whether any decision has been taken pursuant to the representations so submitted by the petitioner on 28/3/2023. The learned counsel, appearing on behalf of the Guwahati High Court, submitted that the committee so constituted to amend the Guwahati High Court bracket appointment, conditions of service and conduct bracket close rules 1967 have granted certain opportunity to the Guwahati High Court Principal Seat Employees Association to submit a representation. And as the representation has not yet been submitted by the said association, the committee have therefore not further deliberated on the matter. Full stop. Mr. H. Betala, the learned counsel appearing on behalf of the petitioner, submits that the petitioners would like to file a separate representation independent of the representation to be submitted by the Employees Association. Full stop. Taking into account the above, liberty is given to the petitioners to submit a fresh representation before the committee constituted to amend the Guwahati High Court bracket amend appointment conditions of service and conduct rules 1967. And the committee and the Guwahati High Court on the administrative side shall consider and the committee so constituted by the Guwahati High Court shall consider the same independent of the representation to be submitted by the principal by the Guwahati High Court Principal Seat Employees Association. Full stop. You submit.
I'm so grateful.
Ah. List the matter after 2 months. 2 months.
February,
2 months.
sorry, meeting.
2 months.
Fine.
We can have a date out there on 5th or 12th of
February.
12th of February.
Discuss.
Oh, yes.
Won't be difficult.
Ah.
Right, I discussed. Will be some interest clash. Because 1, 2, 3, 4, after filing an affidavit, I called them. I said it will be difficult, let 3 and 4 withdraw this. With an affidavit before the court, they are not pressing it. So for a 3 and 4 is concerned. This is what I suggested, because there will be a clash. Because 1 and 2 and 3, 4, now I have come to know. 3 and 4, anyhow, they are not entitled. Now I am ventilating a cause of all the 4s. Now that will be difficult on my part, I realize. So I will file an affidavit. Before the court, I said, you have to swear an affidavit that 3 and 4 is not pressing. Otherwise, there will be a clash. There will be a clash, it will be difficult, my lord. I think I should not, my lord. I didn't knew because once affidavit came, I went back. Your lordship is absolutely correct. I called them. I said, this is the position. What to do, you tell us. They also agree. I think we should bring it by an affidavit. It is not made by verbal saying it. Tomorrow again they come, no, I have not done it. So I have called them and.
Not by way of an affidavit,
Yes,
an IA,
I will find an. Yes.
by
that-
which these two
Correct,
persons
correct.
have to withdraw
Yes,
from the writ petition in terms with and with the liberty to refile.
yes, correct, my lord. That's what I also, it will be not, affidavit will be IA, correct. I will do that, my lord. Ultimately, I found that I.
Because recasting, no problem. We can direct recasting. But the only thing is those 3 and 4 will be affected.
No, then I am representing, that's the whole problem. I realize that it will be a problem for me also. Somebody will argue, that's a different thing.
Like Mr. K. Mohammed,
I
after you left, he was making the argument. That notice has to be given, all these things have to be given. Forgetting that the very appointment of them or very promotion of those persons for whom they got the appointment was subject to the outcome of the
Yes, it is
petition.
possible. That is there already. You have already indicated that part.
Didn't they
That is-
submit? Okay. Okay, we adjourn it. Mr. D. Das, the learned senior counsel appearing on behalf of the petitioner submits that he had been instructed by Mr. K. Mohammed appearing on behalf of, who is his assisting counsel, that the respondent number, petitioner number 3 and 4 would like to file an independent, would like to file an interlocutory application in the instant proceedings. He therefore submits that some time in that regard may be granted. List this matter again on when?
You opening?
8,
Yes. Problem.
8. So and so appears for such.
Quickly observe.
You got the money?
Money 3,50,730.
Huh?
3,50,730 credited on 27.
Other deduction part.
Deduction might be there.
Mr. M.K. Hussain, the learned counsels appearing on behalf of the petitioner, that the petitioner had duly received his dues after making, dues after the statutory deductions. And as such, the petitioner would not like to further pursue the instant proceedings. Mr. K. Gogoi appears on behalf of the state government, who's taking into account the above, the writ petition stands closed as it has become infructuous.
My lord, this is a matter of removal from service for unauthorized leave absent during the period of 1st of June 2020, during the peak COVID period. So record was called for, as per the last order by law.
I have got the
Called
record.
for, and if possible, today it was to be restored.
I have got the records, my lord, but prior to that, my lord, will kindly have a look at the prayer, my lord, of the writ petition. I think he has to correct it. Removal order bearing number 8/10/2015. It's nowhere there in the entire writ petition.
Huh?
Page 9, prayer.
Where is that order?
Order is just, my lord. Page number 50,
Page?
52.
And apart from that, my lord, the appellate order and the penalty order not challenged. My
Page
brother had to-
5/3/2024.
My lord, this is a typology.
What date have you put? 8/10/2015?
I apologize, my lord. I apologize.
And the appellate order also has not been challenged.
The council, how can somebody help you? You are not challenging that.
Appellate order to challenge 409.
You withdraw and file a fresh one. You have a good case. I'll put it as your fault. And say that you will withdraw and therefore refile.
Otherwise, my lord, I have got the records, my lord. Records has come.
But he has not challenged that.
He has not challenged, that's
Maybe
why
it
I'm
is
sure.
the Guwahati High Court matter, but then also how can I issue a certiorari if you are
No,
not challenging that order?
No.
I challenge the original.
I have to issue, I have to issue a certiorari.
Correct, my lord.
So I can't, he's asking for his appointment order to be set aside.
Ah.
2015 must be your appointment order.
No, it's nowhere there, my
I
lord.
think it's taken.
You must have, made that overnight, I suppose. Huh?
I
Half you must have went to sleep or your stenographer must have went to sleep. Okay, Mr. D.K. Nath, the learned counsel appearing on behalf
Appeal
of
to
the
quit
petitioner submits that there has been an inadvertent error in the writ petition by not challenging the termination order as well as the order passed in the appellate appeal. He therefore submits that as it is his mistake, he may be permitted to withdraw the instant writ petition with a liberty to refile, taking into account that on account of the mistake committed by the counsel, the client should not be penalized. So taking into account the above, the instant writ petition therefore stands closed on withdrawal. However, liberty is given to the petitioner to refile by challenging his dismissal order as well as the appellate order by which his appeal has also been dismissed. Mr. H.K. Das appears on behalf of the petitioner, Guwahati High Court.
It's removal order, my lord, not removal order, not dismissal order.
Okay, removal order.
হব, হব, হব। We have filed the affidavit here, ma'am.
It's a copy of petitioner.
What? Without serving copy, they have filed
No.
it. What is this power?
File.
Huh?
SK Das.
It
my lord, I
appears
have
that
filed.
you have exercised some power
No.
because who has filed? The district and session judge has filed, so he need
No,
not comply
no,
with the necessity
No.
of giving a copy.
Your senior, it has been given to your senior, Mr. Das.
Second,
Huh,
he didn't tell me actually.
okay, it has been given to him.
Okay.
Somebody has received it. Who is this? Some SK Das. Who is he?
Get counsel of this matter. Tell me actually.
SK Das received it on 10/12/2025. Today is 10.
No, yesterday, my lord.
Some Sarkar Kumar Das or something. What is his name?
Santanu Kumar, the
Santanu Kumar.
her
Das.
senior.
Put his signature in such an ineligible manner. Nobody could understand. Is he connected with you? Santanu Kumar Das.
My senior still are.
A Nath.
Whom affiliated?
A Lal. And is A Lal connected with Santanu Kumar Das?
I
You
can-
gave it to some wrong person.
No, Mr. SK
হ্যাঁ,
Das-
এখন ওকালতনামা করুন, সমস্ত পুনে কোনে ফাইল করছে।
SK Das name is there, my lord, in the cause list.
What is this? Who are you?
Ebo.
You are not there.
Okay, how about Ella?
Ah, none appears for the petitioner means. We dismiss for default. You have no business. First of all, the person who have received, he is not here. A person who has no business has said that she has not received. Can there be anything more funny in this episode? Is the winter, arriving of the winter vacation means having some problem with it? None appears on behalf of the petitioner on call. It is also noticed that the respondent number
1, 3 and 4.
1,
1, 3 and
3
4.
and 4 have duly filed the affidavit in opposition. For the ends of justice, the matter stands adjourned to be listed again on 12th of February 2026. In the meantime, liberty is given to the petitioner to file any reply. Interim order is there?
No, there is no interim order.
Okay, chalo.
Oh,
May I please your lordship? Lordship, this application has filed saying of the written examination which was supposed to be held on 7/12, and it has already been conducted, lordship. So I become infatuated.
Examination over,
Yes, Lord.
infructuous. Then
Lordship, in the other matter, I,
what are you challenging?
lordship,
This is in connection with which petition? 3666.
366, 2000.
What is your case? Let us see.
Lordship, in this matter, we have challenged on the advertisement dated 3/5/2024, lordship.
What are you challenging here?
Lordship, a new advertisement of fresh advertisement was issued, lordship.
Who are you?
And I am in waiting list number 2, lordship,
Of
of selection list, lordship.
which selection list?
22, my lord, which is at page 26 of 3666. Annexure 6, my lord.
What is that?
That was the selection was held on 26/4/22. my lord,
8/7/2021.
At page 26, my lord.
20?
26 of read petition 3666.
This is for the year so and so pursuant to the advertisement dated so and after having qualified in the post of Jari Karak.
Yeah.
What is your name?
My name is Jitu Mani Saikya.
Where?
At page 27.
OBC.
OBC serial.
Then what
two.
happened?
Lordship, the persons who were appointed at serial number 2 and 4, they have resigned from the post, lordship. This is
Who?
overqualification. The person who, at page 26, lordship,
Ah,
serial number 2 and 4,
ah,
the persons who were appointed,
ah,
they were resigned from the post due to overqualification, lordship.
ah.
So.
So your case is that you being in the waiting list, you should be appointed.
Yes,
And because of that, you have filed a petition. My goodness.
Law is well settled, my lord.
Let us not go into that aspect of the IA. I should not say that it has become infructuous. I will close it, saying in dismissing of the writ petition is the result for closing. Yes, so many judgments are there.
My lord.
What
Ah.
right you have? You have?
Yes, my lord.
See? Many judgments are there. Recently also our judgment has been given. And what is the other writ petition for? 1056 is for what?
lordship, in the petition, we have said to be appointed on the post, which is,
Ah.
vacant, lordship.
Should not be issued to appoint the AI in the post of Jari Karak against the resultant in connection with the advertisement dated so and so. So this 1056 is pursuant to those two persons going out. So you want the direction that you should be appointed. And the second is that they have initiated some selection process
Yes, my lord.
that you have challenged the advertisement and the court did not state. Now thereupon they filed an application that now they were taking up steps for written examination. So you are therefore come with an IA. All these are the three things. Chalo. We dispose of all three. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. And Mr. G. Bush, the learned standing counsel of the Guwahati High Court.
Also, in second matter, I am respondent number 6.
Who are you?
Witlisted candidate number 1.
You also have no business.
No, they have beat me up and they said that
But, he also wants to have sail in the same boat. Mr. R.J. Das appears for the respondent number 6 in WPC number 3666 in WPC number 1056/2024. And Mr. K. Gogoi appears on behalf of the respondent number 1 on behalf of the state government. the two writ petitions, the two writ petitions are interconnected. And as such, the same are taken up for disposal by this common judgment and order. In WPC number 1056 oblique 2024,
Lordship, I am appearing in this matter on behalf of Mr. D.P. Bora, as per instruction of him, Lordship. So his name also may be recorded on behalf of.
okay, none appears for a petition on call. Don't worry, if he doesn't appear, we dismiss it on that, but merits. None appears on behalf. The WPC number 1056 oblique 2024 is a writ petition filed by the petitioner.
Lordship, can this matter be taken up after some time?
You see, only thing is, after some time when Mr. D.P. Bora comes, his name will be there. By the time my judgment is over, if Mr. D.P. Bora doesn't come, his name is not there. Only difference is otherwise. Otherwise, you don't disturb any further. You are disturbing while I am dictating. So therefore, don't disturb. In the meantime, you can go searching for Mr. D.P. Bora, find out anywhere if he comes. By the time if I finish my judgment, he need not come. So you have another junior waiting out here, send him by an SMS whether he is there by the time the judgment is. WPC number 1056 oblique 2024 has been filed by the petitioner seeking a direction that the petitioner should be appointed against the petitioner being a waitlisted candidate should be appointed against the vacancy which have arisen in view of the resignation of the selected candidates in the OBC category. WPC number 3666 oblique 2024 has been filed by the same petitioner challenging the actions on the part of the respondent authorities to initiate the process for selection for filling up the vacancy of Jarikarok in the OBC category, which came into existence in view of the resignation of the selected candidates in pursuance to the select list dated. Where is the select list?
Yes, my lord, at page 26, my lord, annexure 6,
In pursuance to the select list dated
26
26/4/2022. Full stop. The legality and the question which arises in the instant proceedings is as to whether the petitioner herein is entitled to any relief as have been sought for. Next. For deciding the same, this court finds it pertinent to take note of the brief facts which led to the filing of both the writ petitions. Full stop. The office of the district and session judge, Hojai Ahom, Hojai, had issued an advertisement dated 8/7/2021 for filling up of various posts. Full stop. Various posts, which includes 5 posts of Jarikarak. In the same advertisement, it is further mentioned that out of the 5 posts, 3 posts were for unreserved category. It was mentioned that 1 post was reserved for OBC, 1 post was reserved for STP, bracket P, and the 3 were in the unreserved category. The petitioner, who belongs to the OBC category, participated in the said selection process. Full stop. On 26/4/2022, a select list was published in the order of merit for the post of Jarikarok. Full stop. The petitioner, however, did not find place in the said select list amongst the 5 selected candidates. However, the petitioner was put at serial number 2 in the waiting list in the OBC category. Full stop. It is the further case of the petitioner that that one Kapil Dev Shah was appointed to the post of Jarikarok in the OBC category. Full stop. By an order dated
16/7/2022.
16/7/2022.
2022. Kapil Dev Sharma on 29/9/2022.
29?
9/2022.
No, 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 no. That he was released. He was released on 29/9. He was appointed when?
We have filed affidavit, my lord, at page 62, 61 and 62. Annexure A and B of my affidavit. my lord. There were 2 OBC candidates.
No, no. One OBC has on merit, he has already gone it.
my lord.
It's not relevant. Where is his appointment letter?
These are, no, appointment letter we have not annexed. We have annexed the resignation letter.
The Bijoy Sinha's resignation has no material bearing, taking into account that he, being in the OBC but having merit, he was adjusted against the unreserved category. That has
My
no relevance.
My lord.
It is the case of the petitioner that the said Kapil Dev Shah,
My lord.
who was appointed in pursuance to the select list dated 26/4/2022, was issued a show cause notice inasmuch as the said Kapil Dev Shah had wrongly was not eligible to apply for the post of Jarikarak as he was overqualified. Pursuant thereto, the said Kapil Dev Shah submitted his letter of resignation on 27/9/2022 due to personal reasons. It is therefore the case of the petitioner that as the post of OBC in the post of the Jarikarok in the OBC category fell vacant, the petitioner who was at serial number 2 of the wait list should be given appointment, should be appointed against the said post. In that regard, the petitioner submitted a representation. Where is that representation? No representation. Direct. Very well. No representation also. You have given a representation. No. The petitioner, thereupon, having not been appointed against the vacancy, approached this court by filing WPC number 1056/2024, seeking a direction that the petitioner should be appointed to the post of Jarikaro against the resultant vacancy which arose in view of the resignation of Sri Kapil Dev Shah. The record reveals that this court, by an order dated 28/2/2024, issued notice first. However, there was no interim directions passed. The records reveal that respondent number 3 has filed an affidavit in opposition. Wherein the facts above noted were duly mentioned. And it was further mentioned, above the mention, it was duly mentioned. Apart from the fact that in addition to Sri Kapil Dev Shah, one Sri Bijoy Sinha had also tendered resignation, as he had also applied to the post of Jarikarak. On the ground that the said Bijoy Sinha was overqualified to apply to the post of Jarikarak. There is no mention in the affidavit as to why the petitioner cannot be considered. For the post which fell vacant in the affidavit in opposition, except the fact stated that the petitioner never approached the respondent number 3. Where is that statement?
My lord, kindly pay this paragraph 14, my lord. We have stated that by relying the Supreme Court judgment,
Where? Para?
14, my lord.
Of?
My affidavit in opposition
In which case?
in 3666, my lord.
No, 3000, no, 1056. 1056 is his case that he should be considered. Full stop. The record further reveals that while WPC number 1056/2024 was pending, the respondents took a decision the petitioner came to learn that the respondent took a decision. No, the respondents took a decision to fill up the 2 vacant posts of Jarikarok, which arose on account of the resignation submitted by Sri Bijoy Sinha and Sri Kapil Dev Shah, and accordingly issued an advertisement on 3/5/2024. Now tell me, one was an OBC.
My lord.
Where is that post gone?
My lord,
See the advertisement of 3/5/2024.
she unreserved, one OBC and one STP.
Kindly come to page 44 of the writ petition in 3666. You see, Kapil Dev Shah was an OBC.
OBC,
He resigned.
my lord.
Bijoy Shah was an unreserved. He resigned. So you have 2 posts.
2 posts.
Now kindly see the advertisement which was published on 3/5/2024.
44. Hmm. One OBC.
Huh?
One OBC, one unreserved.
Where is it?
At page 45, madam.
Ah, or it is one of which, okay.
Right.
Issued the advertisement dated 3/5/2024. The petitioner being aggrieved challenged the said advertisement dated 3/5/2024 by filing WPC number 3666/2024. This court, by an order dated 24/7/2024, issued notice. However, there was no interim directions passed. Full stop. Today, when the matter is being full stop, it is further seen that during the pendency of both the writ petitions, a notification was issued on 12/11/2025 for filling up of the post of process server in the establishment of the district and session judge, Ujai, pursuant to the advertisement dated 3/5/2024. The petitioner, coming to learn about the same, had filed an interlocutory application seeking stay of the written test, which was to be conducted on 7/12/2025. The record further reveals that the respondents have filed their affidavit in opposition in WPC number 3666/2024, wherein it is the specific stand of the respondents that the waitlisted candidate has no right to claim appointment upon the resignation. Now, after appointments have been duly made in favor of the selected candidates. If a vacancy arises pursuant to the resignation, the same is required to be filled up by following the mandate of Article 14 and 16 of the Constitution. First, in the backdrop of the above, are you appearing?
Lordship.
Not appearing.
Appearing lordship, one,
Not on. Are you appearing?
yes, lordship.
Then I'll say submission. Otherwise, no submission.
Lordship, my name may be record.
আগৰ নামটো ভৰাই দিব তাত। In the backdrop of the above, this court duly heard the learned counsels appearing on behalf of the petitioner as well as the respondents, whose submissions were in tune with the judgment, in tune with their pleadings. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submitted that taking into account that the said Kapil Dev Shah would not have was not eligible the very appointment order was non-est. And as such, it cannot be construed that the post was filled up by making a due appointment. And under such circumstances, the petitioner had the right, being in the waitlisted candidate, to be appointed against the vacancy which arose on account of the resignation of Sri Kapil Kumar Dev Sir. He therefore submits that instead of considering the said, the respondent authorities have initiated a fresh selection process by the select list dated by the advertisement dated 3/5/2024. And as such, this court may pass appropriate directions upon the respondent authorities to appoint the petitioner against the vacant post in the OBC of Jarikarok in the OBC category, and set aside the advertisement dated 3/5/2024 insofar as the post of Jarikarok in the OBC category is concerned. Anything more? Mr. G. Boisha, appearing on behalf of the respondent, Guwahati High Court, submits that the petitioner herein have sought for a writ in the nature of mandamus seeking directions upon the respondent authorities to appoint him against the vacancy which arose out of on account of the resignation of Sri Kapil Dev Shah. The learned council, standing council submitted that the petitioner never approached the respondent number 3 and directly approached this court. On this aspect alone, the writ petition being WPC number 1056/2024 is required to be ought to be dismissed. The learned standing council further submitted that if WPC number 1056/2024 is dismissed, nothing further remains in WPC number 3666/2024. On merits, Mr. G. Boisha, appearing on behalf of the respondent, submitted that pursuant to the appointment made to Sri Kapil Kumar Dev Shah,
Kapil Dev Shah, my lord.
Kapil Dev Shah, the select list, which was published on
26/4/2022.
23/6/2024.
At page 26, annexure 6, my lord.
26/4/2022 had already exhausted insofar as the OBC category is, the post of Jari Karak in the OBC category is concerned. It therefore submitted that the waitlisted candidate therefore has no right, and none of the waitlisted category candidates in the OBC category had any right, and not to speak of the petitioner who was at serial number 2. In that regard, he referred to the judgment of the Supreme Court in the case of Thrissur District Cooperative Bank Limited versus Delson, Davies, and others, reported in 2021, 14 SCC 407. Anything more?
That's it. My lord, few more judgment are there, my lord. We can.
Is it something like that you are today thinking that all matters are getting dismissed either on withdrawal or something? So let me make a better judgment by putting some more judgments. It's a repetition, isn't it? What do you say? Okay, we'll look into that judgment. What do you say about the wait list as per the rules? The concept of waitlisting as per the rules vis-a-vis the AFRBM Act, which permits there cannot be a waitlist. I'm coming back. Then only I will consider your other judgments. Yes.
Nowadays, in the High Court, no waiting. We don't keep any waiting. If not joined, next election. And then lower, in the CJN court and district judge, they are still following procedure.
But I have passed 4-5 judgments on that point. You cannot have a wait list.
And wait list, really for one.
No, the concept, because it is an act. AFRBM is an act. Those are rules. Those rules, why you are required to have a wait list? Because you are also going to, the very concept of the wait list was that at the beginning of the year, the district judge will find out what are the vacancies and which are the anticipated vacancies to arise in the entire year. So what happens, those vacancies which are there as on the date on which the selection is done, so they have a select list. And those which are going to happen, they have a wait list. So here you are doing against because what happens after the AFRBM Act, you cannot have against anticipated vacancies. So therefore, it has to be only against those posts. That is the mandate. Now, the analysis and determination. This court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials on record. From a perusal of the advertisement which was issued on
873.
8/7/2021, it is seen that the said advertisement was issued for filling up of 5 posts of Jarikarok, out of which 1 post was reserved for OBC, 1 post for STP, and 3 posts for unreserved category. It is also seen that Sri Bijoy Sinha, who was an OBC category candidate, on account of his merit, was selected against an unreserved category post. Whereas Sri Kapil Devsa was selected against the OBC category post. There is no denial to the fact that these posts, which were the select list, which was issued on 26/4/2022, was duly acted upon, and appointments were given to all the selected candidates appointed to the post of Jarikarok. It is also seen from the materials on record that on account of information available to the District and Session Judge Hojai, so-called proceedings were initiated against Sri Bijoy Sinha and Sri Kapil Devsa on the ground that they, while submitting their applications, did not disclose that they were overqualified. The records also reveal that both Bijoy Sinha and Sri Kapil Devsa have resigned. The question therefore arises as to what is the effect of their appointment pursuant to the select list, and as to whether the waitlisted candidates would have any right to get selected against those posts wherein vacancies arose on account of the candidates, namely Sri Bijoy Sinha as well as Sri Kapil Devsa, having submitted their resignation. The answer to the same can be seen from the judgment of the Supreme Court in the case of Thrissur District Cooperative Bank Limited, Supra, wherein the Supreme Court observed that once the selection process is complete and the appointments have been made, that process comes to an end, and if any vacancy arises on the on the appointee having joined the post leaves the same, it must be treated as a fresh vacancy. Paragraph 3 of the said judgment being relevant is reproduced herein under. The above quoted portion of the judgment paragraph, if applied to the facts of the instant case, would show that the resignation of Sri Bijoy Sinha and Sri Kapil Dev Shah has, and the resultant vacancy which has arose in the two posts of Jarikarak, one in the unreserved category and other in the OBC category, are fresh vacancies. And as such, the petitioner cannot therefore have a claim to be appointed against those vacancies on the basis that the petitioner was a waitlisted candidate. The resultant effect of the above analysis is that if the petitioner cannot have a right or a claim against the fresh vacancies which have arisen, the petitioner also do not have a right or a claim to seek quashing of the fresh select list, a fresh advertisement issued on 3/5, what is that date?
24.
3/5/2024 for filling up the two posts of Jarikara, of which one is reserved for the OBC and the other unreserved. Conclusion. In view of the above analysis and determination, the instant writ petition stands disposed of with the following observations and directions. Number 1, the writ petition being WPC number 1056/2024 lacks merit and accordingly stands dismissed. Number 2, the writ petition being WPC number 3666/2024 lacks merit and accordingly stands dismissed. Number 3, there shall be no order as to cost. In view of the judgment and order passed in WPC number so and so, the instant application stands closed.
Deeply obliged.
You want whose name? Name to word. Have you worked out or not what I asked you? It's not required for you to assert it. You know you own Dag number 5. You own that Dag number 5 was given to you. Out of that, various other Dags were formed. So the main thing is, in that very Dag, thereupon there is no, in that Dag, that you have not sold any portion of land to the CRPF. So the resultant effect is the demarcation can be very well carried out, showing that because they have the map of the old Dag number 5. So old Dag number 5, if there is any encroachment, the map which they have belongs to either you or your successor in interest. Isn't that the calculation? Where is Miss Agayan?
She's here.
You may have a fight with the successor in interest. These other ducts, the small ducts which have been formed from original duct number 5, are results of you selling it. No, entire duct number 5 fell in your share. So there's no quarrel. Out of that, 8 ducts came into existence. Of these 8 ducts, some portion of some ducts have been sold to somebody. So the right over that land either would be of you or your successor in interest whom you have sold. So that is it. But CRPF has no rule. Yes, madam. Yes, Ms. Egan. What happened? Last time you went to the circle officer, what happened? Circle officer invited you on 17/11/2025 for what? Cup of tea?
That I was there. So, my lord, the council, one of the council of the petitioner was also there, my lord.
You say the council or no council, I don't understand. But the fact remains, as would be seen, they don't have the revenue map for the smaller ducts, but they have the revenue map for the original duct number 5. If you see the Jamabandi, you will see that these smaller ducts comes into existence from the original duct number 5, of which one portion of duct number 5 is retained and remaining are small 8 ducts formed. But that revenue map for the entire duct number 5 is there. So from that, why they are not able to ascertain that? My question is that, and from that entire duct number 5, you don't have a single plot of land. Because it has to be either sold by them,
Yes,
which they have not.
yes, madam.
The government cannot allot that land to you because it is the duct number 5 was theirs. So could not have allotted
Yes,
that
madam.
land, meaning thereby you are in, if you are in any portion of duct number 5, the old map, you have to be evicted or you acquire. We are not concerned. Yes, the right may not be absolutely of the
The
petitioner.
petition, yes.
It may have some right with the
They
other
already
persons.
sold- They have already. sold.
So that circle officer can very well look into their sale deeds
Yes,
and thereupon verify as to whether the petitioner exclusively is entitled to any compensation or the petitioner is not entirely exclusive to the year. But that will depend at the time of acquisition.
yes, madam.
So they may have it.
Yes,
So
ma'am.
then those persons who are not there, they can very well claim.
Yes,
But the
madam.
fact remains that whether you want to be in duct number 5,
Yes, madam. So, my lord, on that issue, my lord, I'll think whether they are going to vacate the land or they are going to acquire the land, my lord. Only on that purpose, my lord, I'll take instruction, my lord. Because as the fact is that duct number 5 is there, but though they sold to someone, my lord, that is another fact, my lord.
that is for those persons to claim if
Yes.
you acquire.
Yes, my lord.
Just for example, tomorrow you vacate it.
Yes, my lord.
They may have a fight inter se
Yes.
between him and those persons,
Yes,
which I am not here to adjudicate.
yes.
So let them do what the fight they have. But the fact remains that you are in duct number 5 where you don't have right.
Yes.
So you are to give up that portion which is there and which portion you want to retain.
Yes,
You
ma'am.
provide that details
Yes, ma'am.
next date.
Yes, ma'am.
Which portion?
Hit me now.
August, the lordship's order. They have made a same place. 21st August order, para 4. we are seeing that they want to, okay, instruction. that will be given.
তাৰপিছত এইটো আহিল ন ভেৰিফিকেশ্যনৰ হেৰিটো আহিল এইটো তাৰপিছতে After that, my lord, petitioner and both of we have filed a application before that, my lord. That is that development raised, my lord. After that, that's why, my lord.
No,
Yes,
we
my
have
lord.
not filed that appeal. I got a copy, we have
No.
asked for demand.
No, that is there, no. That is this asking,
No, no, the demarcation you know.
or not
See,
demarcation, yes.
Mr. Hendrik, I don't understand the circle officer also. He has the map of the circle of dark number 5, original. And dark number 5 under no circumstances belongs to the CRPF. Any portion thereof. Because original dark number 5 belonged to him. From that original dark number 5, when it belonged to him, it was bifurcated into 9 darks. Out of which 9 darks, some portion of the land has been sold to somebody. So it may have a right vis-a-vis the petitioner and somebody else, which is another dispute, which you are not concerned. But the fact remains that you have the map for the original dark number 5. So you demarcate the original dark number 5 as it is, as per the original map. Forget about the subsequent bifurcations. And then submit a report, and in the meantime, you
Yes,
take it up
Yes, my lord.
and retain which portion, how much you
Yes,
want
ma'am.
to retain,
Yes.
and they will measure how much land is they want to retain and how much. That is the only scope left. How much land they will only like to retain. That measurement has to be carried out.
Yes.
Now, madam, the fact is what is happening is you are also not coming, your party is not also forthcoming. You want to retain how much land, you can very well find out. You don't need the dark number or
Yes,
patta
my
number
lord,
for
yes.
that. You require
Whatever is
1
their
bigha of
possession, my
land.
lord, yeah, ma'am.
You require 2 bighas of land, you require 5 bighas of land is the area which you want to retain. You have
In
to
dark
come up
number
there.
5, my lord.
Why you are not able to measure it? Get it measured. That can be measured by any mondal.
That can be done by the
That
only
can-
Mondal.
The mondal can very well do it. How much area of land they will
We-
like to hear.
we want.
And then to find out as to whether remaining you want to vacate, you vacate it. How much? And as to whether that portion out there which you want to retain falls within dark number 5. If that be so,
Yes.
then proceed.
I'll clear that, my lord, in next day.
We further concise it now to this,
Yes,
that you are to file an application before the circle officer within 10 days. How much for seeking a measurement of the area which you want to retain? How much area you want to retain? So he will make a measurement. The circle officer thereupon will ascertain as to that area where he is going to, you want to retain, falls in old dark number 5 or not.
Sir, can we give some more time instead of 10 days, my lord, for
No,
application?
you are filing an application.
Yeah.
You are not filing the measurement.
Yes, ma'am. Because, my lord, they have to take approval from the higher authority also, my lord. CRPF cannot, my lord, give their.
Isn't it your submission made on the last occasion and on an affidavit being filed to that effect that you are going to retain only some portion and some you are giving up?
And then, my lord,
Then where is the question out there? That is your basic case which you have stated in your affidavit.
yes.
You cannot come up with another stand now that you have to take an approval.
No, I'm not that for, my lord. I'm just taking some more time instead of.
Or
10
what? You submit that
Yes,
application.
my lord.
In
Whether
fact,
we are going
in
to
fact,
retain-
didn't you make a submission that 17/11/2025 you were invited in view of an application filed by you
Yes, ma'am.
that to find out exactly which portion of the land you want to acquire? So that is what I'm asking you. This is in furtherance to that. You are asked for the measurement.
Yes, ma'am.
Now, once you get the measurement, just for example, it may be 2 bighas, it may be 3 bighas, it may be 4 bighas, whatever it may be.
Yes.
Then once that measurement is being carried out, then the circle officer will ascertain by carrying out a demarcation as to whether this land falls within the original dark number 5 and then submit a report.
Yes, ma'am.
With
Yes,
that,
sir. Yes,
then the question arises, if it falls under dark number 5 of the original one, then you are to take up the issue of
Ac-
acquisition. How you have to do? First, heard Mr. A. Das, the learned counsel appearing on behalf of the petitioner. Ms. A. Gayan, the learned counsel appearing on behalf of the CRPF. And Mr. J. Jagdik, the learned counsel who appears on behalf of the circle officer of the district administration, including the circle officer, Hunapur Revenue Circle. The materials on record, the various orders passed hearing above, including the order dated 21/8/2025 and a perusal of the latest record of rights bracket Jamabandi reveals that
Inilah kita balik. Itu pasti nanti kasih. Agak last sorry.
out of dark number, original dark number 5 of patta number, huh? Patta number 6 of village, village, Korutari, and the Hunapur Muza, comma, that the dark number, original dark number 5 of patta number so and so of village so and so belonged to the petitioners. Full stop. The circle officer, Hunapur Revenue Circle, duly admits that he has the map of the old dark number 5. Full stop. The record further reveals that out of the original dark number 5, various new darks were formed. Page. That is dark number 5, 56, 58, 51, 50, 49, 46, 45, 44. এইটো ওপৰৰ পৰা দিব দেই 44, 45, 46, so and so, and 5. Totaling to 14 bighas, 1 katha, 7 lachas. In the additional affidavit filed by the where is that map?
Map pun di sini.
I- In the additional affidavit filed by the huh?
It is marked as that one.
Z.
That one, that one.
Asan?
Z1 is where?
That one represents both of the circuit officer. That is map one, color.
There is annexure Roman 5. Now, this is the map we is being also enclosed by them
Yes.
also in the affidavit. In the additional affidavit, they have filed it. Huh?
It's more clear, this one.
No, in the additional affidavit,
The
annexure A to the additional affidavit filed by the CRPF.
Yes, madam. Annex A, page number 112, madam.
11,
2, madam.
113, 135.
Yes.
112, 135. কি লিখলে? In the additional affidavit filed by the respondent CRPF, the said map have been duly enclosed. This very map can also be seen from the reports submitted by the Circle Officer, Hunapur Revenue Circle, and before this court, and kept on record as Z1, kept collectively on record as Z1. The above. Map shows that the CRPF or army, it's army or CRPF?
Yes. Yes.
That the CRPF, that the CRPF authorities are in possession of 11 bigas, 2 kathas, 17 lechas. And in their possession, some portion of the original land of the original Dag number 5 falls. This aspect is an admitted aspect, as would be seen from the affidavit filed by the respondent CRPF authorities. It is further seen from the affidavit filed by the respondent CRPF that though they are in possession of certain portions of Dag number 5, old Dag number 5, they would like to retain certain portion by carrying out acquisition and give up certain portion. This stand is absolutely clear. Taking into account the above, this court it is also very pertinent to observe court had adjourned the matter earlier. On the ground, on the submissions so made by Ms. A. Gayan, the learned counsel appearing on behalf of the CRPF authorities, that pursuant to certain application being filed, the Circle Officer, Honapur Revenue Circle, have asked their presence on 17/11/2025.
There's the 7.
7/11/2025. It is seen that till date nothing substantial have progressed. On account of the circle officer, Honapur Revenue Circle, insisting on the actual determination for nothing substantial on account of the circle officer, Honapur Revenue Circle. Not taking appropriate steps in that regard. Mr. J. Hendick, the learned counsel appearing on behalf of the Sonapur Revenue Circle, Circle Officer Sonapur Revenue Circle, submitted that again demarcation is required to be carried out, but this court fails to understand as to what the requirement of again carrying out any further demarcation once a demarcation have already been carried out and report submitted before this court. In view of the above, this court therefore passes the following directions. The respondent CRPF authorities are given time till 5th of January 2025 for submitting an application before the Circle Officer, Honapur Revenue Circle, for measurement of the land which they wish to retain under their possession. The Circle Officer, number 2, Honapur Revenue Circle shall, upon such application filed, forthwith appoint a mandal as well as other revenue officers for carrying out the measurement of the land which the CRPF authorities seeks to retain. And not later than, such measurement be carried out within 15 days from the date of submission of such application. Number 4. Upon carrying out the said measurement, at the time of carrying out the measurement, comma, the the circle officer, Hunapur Revenue Circle shall also demarcate how much of the land under possession of the CRPF authorities which they proposes to retain falls within the dark number 5 as per the old revenue map. Or the dark number 5 as it originally stood as per the revenue map. Record there, the copy of which was already submitted. And revenue map, revenue. Prior to, as per dark number 5, which existed prior to bifurcations into various darks, as per the old revenue map. Justo. On the basis of such demarcation being carried out, a report be submitted before this court as to how much area which the CRPF authority seeks to retain falls within the dark number 5 as it originally stood prior to bifurcations. Next. The said report be submitted by 2nd of March 2026. 3rd of March, 3rd is close. 5th of March 2026. The said report be submitted by 2nd of March 2026. The writ petition be again listed before this court on 5th of March 2026. Madam, no further.
Yes, my lord.
Be more, try to cooperate. If you don't file this, we are next time not going to allow any further.
Even, sorry to disturb your lordship. I think 12 and 13, that, some personal influence is taken off for myself.
What is the matter about?
This is a fixed hearing to appointment of staff in the door.
So,
That's fixed for hearing.
hearing, all matters from motion to hearing in my court is always hearing. There is never a case of here. Now today I am putting up a page here. There are no difficulty. Mr. Samoa, you appear. No problem. I am there to help you out.
But otherwise, the difficulties on different parts. My lord, so far the one inquiry was going on. As per my instruction, he told me that the inquiry will be completed and that they are about to submit a report within 1 week. So that is the things, my lord.
Yeah, item 30, there is a departmental proceeding against my client, and the DP has been concluded. I'm told that by this week, or within this week, they are going to provide the inquiry report. If the inquiry report comes, my lord, then the case may take a different dimension. That is why, in that case, my lord, I sincerely pray that if we can wait for a week at least, so things will be different.
We will see when the matter reaches. And if we see that the inquiry report has no bearing, good. If it has a bearing, bad. We'll adjourn if it has a bearing. And can we set aside the inquiry report? We'll look into that.
Court
Don't
will
worry.
consider conveniently.
We'll do. These are things.
Lordship, by the last order, I was required to submit a report, Lordship. I have given a copy.
Where is Mr. H.K. Das? He has otherwise no matter today, except my court.
Lordship, I have visited the office of the BSNL and I have also visited the site. The Assam type building is no longer available. What is it? Oh, no, court of a member.
So it's around 3,500 square feet.
Both floors included, Lordship. Both floors included.
Okay. But can it be, can there be toilet made?
Ground floor, they can make, but the space will decrease. First floor, there is a toilet block. It's very small, Lordship.
Small, but the ground floor, can there be a toilet for
It can be. it can
male,
be,
female
Lordship.
entrance and there?
can.
There's one. And the second aspect is regarding Mr. Gugoi, another aspect pertaining to, I have asked also where's the register administration? Not there.
He's coming.
The thing is, on the ground floor
My lord,
of the GAD building,
my lord.
that used to be a parking space, the entire area.
Yes, open space.
Open space, the ground floor. Can that be converted by making necessary infrastructure? And I'm being told that it will give around 3,000 square feet
Oh, then
plus the toilets.
Well.
If that can be done, then in that regard, it would be the bar, this particular thing where if you construct, taking on lease this 3,500 square feet, and that particular thing, if it is being done,
yes, then it
the
will,
lawyers can be accommodated for the time being.
and if required, my lord, then RCC part can be taken, my lord, in addition to this part, my lord. Yes, if required. Assam type we cannot, my lord.
Two floors and the ground floor, then it around 6,000.
500.
6,500 square.
Lots of,
So if that can be done,
yes, sir.
look into that. And both of us propose to visit around 2 o'clock on Saturday in the JD building. To have a look.
Lots.
What is the,
This Saturday. This Saturday.
no, not this Saturday, next Saturday,
My lord,
on 20.
20, yes.
Because this Saturday it won't be possible, but next Saturday on 20, as to how it is progressing.
My lord.
That is what we propose to do,
More appropriate.
including the BSNL.
Lordship.
The BSNL is one. Then how can it be done as regards the ground floor
Yeah.
of that GAD building? How many, the PWD person, if they are there on that
My lord,
day?
one thing I can, my lord, convey to the authorities that, my lord, if some officials, my lord.
Yes, some officials should be
Especially
there.
Executive engineer who are looking into this particular aspect, if they also remains
And
present as
Mr.
you.
Gogoi, not only these two aspects, as a whole construction
Yes.
progress and all,
Yeah.
therefore will require this
Yes.
engineers and all who are looking.
Because we also need to have a look at the court space. The photographs which he has given is very disappointing. And so we like to have a look at the court space and how you are going to progress. We are just hearing it out here, what is happening, somebody is giving something to that effect. Because the photograph which he has given as regards the courtroom of the judicial magistrate first class, it's really disheartening. It doesn't, so that is what we will like to have a look. In the meantime, what progress you want to carry out,
Yes, my lord.
we'll see on 20. At 2 o'clock, both of us will make a visit.
Then, my lord, let the officials of judicial department and my lord PWD buildings may be there.
We'll put it in the order.
Yes, it will be more appropriate, my
Yes.
lord.
And BSNL also it should be.
And- Huh?
BSNL and zone
If anybody from the BSNL is available that day, you kindly make it.
Yes.
I think a person being there would be helpful so that anything can be done. As regards more particularly, if we take the ground floor and the first floor, then the ground floor, the toilet area and all, there will be certain constructions to be made. Now, the PWD would be doing it. So necessary permission in that regard would also be required if it is being taken. So that if you may in the meantime have a talk with the PWD
Yes, sir.
and talk it out if it is possible. And give us what is there on that date. And we'll have it again on, again, 8 we are sitting.
Yes.
8/1/2026, we are sitting again for the other matters. So along with that, we'll have this matter also.
Lord, sir.
We'll look into that. Sure. Anything else anybody wants to say? And what about the speed breakers? Anything, any
My lord, by
decision
Sunday,
taken?
they say, my lord, the PWD roads, my lord. I have already informed them, but they said that by Sunday, they will try to, my lord, give that speed breakers in both sides of the road.
Because something has to be done
Yes, yes,
because
They have been
from
convened.
there, the lawyers are to come here. So something is required to be
Yes,
done
yes.
in that regard.
Now, these are kind of disposable kind of thing, they bring it.
No, not that one, yes, my lord. That part, it goes, my lord, within a few days. Yeah.
That is that
Plastic
the
and-
orange,
Yeah.
what you call fluorescent
Yes.
strips out
Mhm.
there.
So this is with regard to that Sonitpur district. So very minor, the. That's.
So what is happening here? In these regards, as regards the Sunitpur district, what is happening? These repairs are not being done? Yes, but
The building is quite okay also. We don't have any problem to carry out our business from this establishment also. So there is no, my submission is that also. But finding another place for us, it's not required as a also because our building is very good. We are ready to.
are the lawyers willing to pay the differential cost which would amount if tomorrow there's a delay in further construction of the riverside front? If you are willing to indemnify the PWD, it's okay. We are going to protect you till we are not in a position to give you a particular place to sit. Kindly appreciate that. But on the other hand, we also cannot look out, ignore one very important aspect, that if there is a delay in construction of the riverfront where contracts have already been awarded, it would lead to escalation. And at the end of the day, a public exchequer is harmed, whereby your tax-paying money, his tax-paying money, I don't know his, and my tax-paying money and his will be affected. So we therefore need to look into that. You see, as of now, we have protected you and you are being protected till you are not being given a proper alternative area. And as regards that building also, we are not asking them to shift any further till there is proper conducive area in the GAD building. We'll look into that, don't worry. And we on 20, both of us are going. Be there.
Is there any proposal to demolish our building also? We don't have any knowledge.
Have I not passed the interim order?
The government side.
There is already an interim order in your
You
favor.
want to know that there might not be any proposal to demolish.
Yes, sir.
That is his, but that is a part of a riverfront beautification. That will invariably be demolished.
That
So
will be
therefore, to
demolished.
protect you, we have done all these exercises.
We have already passed an interim order now not to do anything. So now they are not doing it also. So therefore, so we are protecting you in that regard. But you have to bear in mind that your affection towards the building has to come to an end someday. Yes.
Permanently to the, but we do not know about that our building is going to be demolished.
Yes,
Yes,
it would be.
it would be.
No, it would be. Therefore, we have passed an order not to do it. You see, we have passed an order.
There are tables,
Fair.
not to affect people.
Not to disturb you. Not to. We have already passed an order.
Yes, the order says order.
Yeah. We further direct that till alternative arrangements are not made for lawyers appearing in the various courts under the CGM establishment, they should not be disturbed from the building adjacent to the present CGM building presently under their occupation. That order is there. But the day on which everything is being transferred out there, then that will happen. But that will take some time. It is not so that it will be overnight or it will take some time. We'll wait. Yes, what is happening as regards this Honitpur thing?
Not, the letters were written on the second last page. Last two pages, mother will kindly have a look. But as of now, nothing has been done from the. and the
Last
back.
2 pages.
Last 2 pages.
7 June later and
And
16 July.
16 July,
What has happened? And, LR has not done anything.
yes, ma'am.
My goodness. Hello, we'll have the LR present on the next date.
Contract for water for 6 units. That has been approved after conversation, that approved is the same process.
Which one?
6 unit residential quarter for the revenue officers.
Sonitpur.
Only one. Sorry to stress. This is approval in that project lots. However,
Sonitpur, there is a
Another project lot.
Another project for construction of quarters.
Ah.
That you have.
That is the land which have been allotted. Yes, so there you have got, yeah, these are all grade 1.
It's not all, I think, different.
This is on a 4 bigha of land. 2 bigha or 4 bighas. It's on a bit hilly, in a hillock. So you are having a G+3.
G+3, 6 unit lots.
G means 6 units. How are you putting it? Mean?
There are 2 building lots, 3 and 3. And it was 1 floor, there's 1 unit, and G for the parking lots.
Okay, G is the parking. Okay. And regarding addition, because you have around 14 officers, how are you accommodating?
And the rest of we are not receiving, but we have chair.
What is the proposal? There is no proposal in this.
Four proposals, in the first page it said finally see four proposals were there, numbers were also given.
Okay. This is existing, serial number 3,
Yes,
quarter number 1, 2, 3, and there will be 6, 7. Total, how many quarters are there in test book?
No, you see why, there is a problem. I think there is a problem with the hillock. You can't have more than G+3 taking into account that land is hillock. That's the big problem out there. But the fact is, what is the size of these quarters? Why the size? You are having a particular, the plot of land is a pretty big plot of land. Then what is the size of these quarters? You means what is the size you are putting it?
Any space left that subsequently in future we can raise another building of 3+3 or 2 buildings? Any idea about this, that project?
Mr. Gugoi, there is another aspect. What we are yesterday in a building committee administrative meeting, we were looking into what is happening is, it is the land is scarce. It's not that you get land so easily, and more particularly in main areas out there. But there is no optimum use of the land. Just for example, in Honitpur district at Tejpur, they have gone for a construction of a G+3 building, where they have put, I don't understand how it was being done. They put the vulnerable witness center of around 2,000 square feet. And they are just going to make, the tender was only for G+3, but G only ground, where they are going to have the vulnerable witness center. And I made an inquiry out there and found out they were not having the spiling done. And as such, they are not going to go ahead with can't go for a G+4. Now, if you ever visit to Tejpur, the district judiciary out there, at one point of time, it used to be a very beautiful place out there. And there you had the heritage type of building, which was made at the time by the British. Now, adjacent to this, you have a ground+1 made for the purpose of the district judge's court. Although it was a G+4 foundation, but it was made G+1, and remaining has been kept vacant. Now, what is happening everywhere? You are having small buildings, just ground floor, and thereby now, if that heritage building you cannot touch, although the government initially gave a sanction of around 44 lakhs, but you can't touch that in view of the opinion being given that if you touch it, it may break off. It's a very old building made by the British. So, I have asked them to stop the construction on the administrative side in respect to the G+3, taking into account they are not having they are not going for a piling. So something has to be done. These are optimum use. Just for example, here, you are having a 4 bigger plot of land. Administrative approval has been given for a G+3 for only 6 units. 4 bigger plot of land is a pretty big plot of land. Getting in Tejpur is not so good. So this is only 6 units. But it is not going to serve it because you are having 14 officers. Then where else would you get a plot of land?
Ask you for land.
Lots of.
So these are main problems which are being faced. So something has to be worked out in that regard. Now, another thing is, there is another plot of land which is nearby. What is that? Nearby another plot of land, two bigger plot of land is there. No, not that one. Not that another hillock where you had the commissioner office, not that one. Nearby there is another plot of land. So there also, if that can be done. Now, if it can be exchanged with the building where you are having the present quarters, because once you have these quarters, you don't require those quarters, the government can very well use those. So something has to be done in that regard, thought about. We don't like the unnecessary spending of the government also on this money, because this is after all public money. You are just making a G+ here. Whether 2,500 square feet is required for a building, for a quarter? It's a pretty big area of 2,500.
In this
You
regard, my lord, if
you must be staying in a palatial house.
No, my lord, I know, hardly, my lord, 1,400 square feet, my lord.
Huh? Now, taking into account that you are the standing council of all departments. 2,500 for a flat is a pretty big area. Huh?
Yes.
Very big area.
Yes.
You see, with such a big area, you have the problem is another maintenance.
Lots.
And I am told that G+3, which they are saying that is all these units, there are some for some much bigger quarters and some a bit smaller.
But here, my lord, if a meeting is held, my lord, if a meeting is held, my lord,
Mm.
with the office of the Registrar General, where, my lord, the PWD building, chief engineer is present, judicial department official is present, and all these aspects are brought to their notice. Now in future, in preparing a detailed project.
No, in fact, that has also, no, that has already been made on the administrative side yesterday. On the administrative side, that has also been requested
Yes, yes.
to the PWD to look into that aspect.
Lordship.
So that will be done. But these aspects,
examples.
these are examples. I'm saying these are examples why you are finding it. 2,500 is a very big area. 4 bighas of land is such a huge big. Nowadays, I think if you have in Guwahati 4 bighas of land, there will be 3-storied, 3 buildings of 3 or 4 buildings, of which one building will be 8-storied each.
Yes. Currently, we're having 9 quarters lots. We're running sort by 6 lots. When it's stacked at 50, 9 we're having a sort by.
So these 6 will complete the project for time being. Again, you will require, there will be enhancement of strength, we suppose in some day or other. Then you
Where will you get the land? My question is that. Getting the land is a precious thing nowadays.
So it should be used to the maximum utilization.
With the futuristic
This
view,
is,
my lord.
this is also another problem. You will construct a building in that corner, then next project has come, you will construct in the middle of the land. Then next time you need a huge project, then you have to demolish all this. There must be
My
some
lord.
futuristic kind of thing. CCTV in there.
And another thing, let's take the example of Tinsukia. In the middle, you have made a construction, whereby it's a just G+1 construction of the district judge's building, without thinking that you are also required in that very building to have other courts. Nothing is being done. And only that, and now that building which has been constructed and inaugurated in 2014 is shrinking. Now, therefore, there is a fresh proposal to demolish this and have a bigger one having everything.
Probably, my
That
lord.
proposal is pending with the chief, I think the chief engineer. The Tinsukia proposal.
What about Choraidev?
Some observation in court's order, my lord,
Huh?
that will help them, my lord, in making the planning and all. my lord.
So do you want to say that we also need on the next day chief engineer of building here?
Yes,
Many projects are pending in his table.
lordship.
Choraidev is first example, then Demaji.
If a list is provided to me from the registry, at least I can, my lord,
Provide the list which are pending in the
Yes,
ship,
yes.
ship.
I will convey.
And the chief engineer, while approving it, should take into also consideration the optimum use.
Yes.
Otherwise, ask these people, because these are not being made by the judicial officers. These are made by the PWD officials out there in the executive department, executive officers. They are making it. Why they are making it? Whether they are actually using for optimal use. Just for example, again, another thing, the toilets. The toilets are just everywhere. We have now passed an order in view of the Supreme Court order for going for the toilets. Now, with these toilets, what are being happening is they are making some toilets somewhere where there is an open space.
My lord.
Just the plinth of not even a small plinth to that effect. Just they are making the floor out there, a toilet out there, which with a little bit of an 50% of the earthquake which we had of Japan may fall down. So this is what it is being done. So there also no optimum use where that toilet could have been done.
For planning, my lord.
Yeah. And these toilets which are being now done around 43, which is now presently, it will be again, you are spending crores of rupees.
Lordship.
It has to be made, but whether it would live the life is not known. Anyways, we will take that aspect later on. You, in the meantime, provide all the proposals pending before that. And also, you being the, also appearing for the LR, we ask the LR to be present. Because at his, in his decks, these proposals can't be kept on pending. He may revert, whatever maybe, he can't keep it pending like this. Like this. Today, the instant proceedings have been listed before us. Pursuant to the order passed on 27/11/2025 for an update as regards the accommodation of lawyers in the GAD building as well as in the BSNL building if the respondent authorities, if the state takes up the BSNL building on lease. Full stop. Mr. R.K. Chaudhary, the learned DYSGI, placed the note before the court, placed the note before us, explaining that there is roughly an area of 3,500 square feet which can be leased out in the ground floor and the first floor of the BSNL building. However, there are no proper toilets for the purpose of no proper toilets. Pusto. We inquired with Mr. B. Gogoi, the learned Additional Advocate General, as well as the Standing Counsel of the PWD, as to whether there has been any discussions with the BSNL authorities on the aspect pertaining to these 3,500 square feet area of in the BSNL building. He submits that he would provide an update on the next date. We urge upon both the PWD as well as the BSNL authorities to look into it as to whether any toilets can be constructed if the land, if the building, if the area is taken on lease. We have been further informed by the register administration that upon carrying out a verification on the ground floor of the GAD building, upon carrying out an inspection on in the ground floor of the GAD building, there is a scope of making further arrangement of around 3,000 square feet of area for accommodating the lawyers and also constructing 5 toilets. First, we are of the opinion that a visit, an inspection is required. Inspection is required to take a first-hand note of the state of affairs, more particularly as regards the court premises functioning in the GAD building. First, the councils appearing on behalf of the respective the council, it has been submitted also at the bar that an inspection in that regard would be useful for further for in furtherance to the furtherance to inspection. An inspection accordingly, we propose to carry out an inspection, visit the GAD building on 20/12/2025 at 2 p.m. First, the PWD officials, and we also would like inspect the BSNL building, more particularly the area which can be leased out. First, the concerned officials of the PWD, the BSNL, as well as the officials from the Judicial Department of the Government of Assam be present on the said date and time. This is for CGM, heading to the Ibode. Apna heading will libo, shifting of the Chief Judicial Magistrate Court, Kamrup Metro to GAD building. Ito heading, huh? You see my order dated 2011-2025, that heading ase. First of other infrastructure issues. We have been informed by the register administration during the course of the hearing that various approvals, various proposals so submitted from the registry of this court have been kept pending in the office of the LR, Government of Assam. Taking into account the said, taking into account that these proposals have been pending since 2022 onwards, we direct the LR, Government of Assam, to be present before this court on the next date. Video conference. Before us on so and so 8/1/2000 on the next date. Gustav. Gustav. We have also been informed during the course of the hearing by the Registrar Administration that various proposals are also pending before the Office of the Chief Engineer, PWD building. First, we are of the opinion that these details be provided to Mr. B. Gogoi, the Learned Additional Advocate General, by 15th of December 2025, so that Mr. B. Gogoi, the Learned Counsel, can obtain necessary instruction as regards the status of such proposals pending before the Chief Engineer building, PWD building. lists the matter on 8/1/2026. For an
Will
update.
direct the, my lord, officials of the judicial department as well as the PW to be present on, my lord.
We have passed
20th.
that
Yes, at two.
on 2012. Huh? Mr. Das is welcome. And remaining, we leave it to your discretion or the register administration. Mr. R.K. Dev Chaudhary, you are welcome. And Mr. B. Gogoi, you are more than welcome.
We have in the meantime filed an additional activity which has been given the lawsuit. That there was a final example. So it's much of examples. Now, lordship will kindly, additional affidavit was necessary for us to bring on record. Because I have to explain for process that is undertaken and what leads to blacklisting. Right, clearly project the process, then perhaps I'll be in a better position to explain that this would not have led to blacklisting. Now, like, lordships kindly take up the additional affidavit and along with, please first have a look at. Last time I did not show this. First, please come to annexure 3 of the writ petition, which is page 39.
Yes.
Annexure, this is the framework agreement. And if lordship will kindly see the next page. What is this for? Assam Medical Services Corporation Limited invites online tenders for empanelment of manufacturers for supply of essential drugs to various health facilities under Department of Health and Family Welfare, Government of Assam by entering into a framework agreement valid for 3 years. So the process starts by this, that you invite willing manufacturers to please empanel yourself. Now, once this is done, once this is issued, we also as a manufacturer of certain drugs, we also apply and we also get empaneled. Those are admitted issues. Now, the next issue that next clause is that important is clause 4B. The clause starts at page 52. Clause, please see clause 4. Evaluation, selection, acceptance, and tender. And what I wish to your lordship to come to is page 53. Bid evaluation. This is critical.
Yes.
May I just place it? Bid evaluation. I am coming to B2, small 2. After conclusion of the empanelment process, a separate process will be followed to discover the lowest price against the particular items amongst the empaneled bidders. Next slide. The process of price discovery will be initiated against every proposed procurement. Purchase orders will be issued in the ratio of 60, 20, 15 to L1, L2, L3, subject to L2 and L3 matches the L1 rate. If L2 or L3 does not match the L1 rate, then the next lowest bidder will be offered to match L1 rate. However, if the value of purchase is less than 5 lakhs, then the entire quantity will be awarded to L1 bidder. Now, my submission on this is each procurement process gives rise to a separate rate contract. And that is critical to understand this difference. Each procurement process is initiated by a separate tender, to which, and that is concluded by concluding a rate contract. So every time a procurement process is initiated, a tender is floated. That is also I'll demonstrate. And that tender is concluded by first fixing the rate and then issuing supply orders to the people who have bidded in L1 and L2. So my first submission, lordships, for your lordship's consideration is each procurement process gives rise to a separate rate contract. And we must also understand the difference between rate contract and purchase orders. A rate contract is a fixed contract, which may constitute more than one purchase orders, but it will relate to the same rate contract. That is itself in the clause.
Now, Lordship, the next clause is 5D, which is at page 57.
Yes.
It is at page 57. Contract rate post empanelment process. Firm rate. After empanel process is completed and the empanel manufacturer asked to submit their price against a specific procurement, then empanel manufacturer shall quote the rate inclusive of all taxes, transportation, insurance, packaging charges, NAPL testing charges, FOR destination and any incidental charges for each of the items it intends to bid for. And this is respect to a specific procurement. If Lordship is connected to the previous clause we saw, that every time you intend to purchase, a new procurement process will be initiated to discover the lowest price. It is like this, suppose there is one procurement process to buy this book. This book I bid at 20 rupees and I get the L1. Next time the same book is again asked by someone, a need arises. This 20 rupees will not, it may be 17 rupees, it may be 22 rupees. So that will give rise to a new rate for that. But every time you have to discover the price within that period.
So here, as per this is bid evaluation at B2
Yes, Lordship.
is for only for empanelment.
Though it is a framework agreement, this, what I'm reading is a framework agreement.
How do you get empaneled?
Yes, how do you get empaneled is, please come to the initial page projects. They give a, in fact, if how you get empaneled is this, please come straight to page 85. And this, I must also point out, Lordships, in this agreement, no quantity is indicated. All that the tender document says, that we will require these medicines.
No, therefore, my question is, how do you get empaneled first?
Yes, we get empaneled because.
Because what you are trying to say, 5D is connected with 4B2. Means once you are empaneled, because the word starting with 5D starts after post empanelment.
Right, Lordships.
They will be asked, those empaneled contractors, that look here, we need this particular thing. They would be submitting their prices.
Lordships.
After the prices are being submitted, then will be L1, L2, and then we have to again come back to 4. Do we have to come back to 4B?
No, we don't need to.
Then how do you find out the L1, L2?
1 minute. We have to come back to. If you come to page 41, objective.
Yes.
Clause B, Roman 4.
Hmm.
For every procurement process, the empanel manufacturers will be asked to submit price of the item. And for-
Therefore,
Yeah.
if this be so,
Yes,
first you get yourself empaneled.
yes, the first step is to get empaneled.
Then you kindly come to 5B,
5D, Lordship. I'll just
which
come.
you have referred to. Kindly see this.
Yes, 5D.
5D, 5D.
5D, yes. Yes,
After empanel process is completed
yes,
and the empanel manufacturers are asked to submit their price against the specific procurement. So therefore, then there will be an L1, L2 will come later on.
yes.
So then thereupon, they will again come to, then the bid evaluation will be done under 4B.
4. That is how the process. That's how, exactly the process. Exactly the process.
So how do you get empaneled first? That is my question first.
That is page 81. I show you this from medicine.
No, it's okay. Means anybody may just apply, will get empaneled.
If you are manufacturing of those medicines. Page 81.
Page 81,
Sorry,
annexures.
Page 85.
Now, these are the medicines,
Yeah.
list of item participated, there's no
Yes.
worry. But how do you, where is it mentioned that if you are manufacturing this, you can get yourself empaneled?
Well, that
Because
is
you
the
see,
dispute, because I am in that.
no, 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 therefore the question is, you are given a letter of intent whereby you are being informed that you are empaneled.
Yes.
Let's see the letter of intent now.
No, first,
Kindly come to page 120.
how we are empaneled is at page 40.
No, kindly
Why?
come to
How-
page, kindly come to page 120.
1.
This is your empanelment order.
Yes, sir.
This is the letter of intent.
Yes. No,
Kindly
this
see.
is not the letter of intent, Lord, sir. That's what I'm
It
trying to
is
tell
the
you.
letter of intent 123. Kindly see.
Page 120 to 123. These are all the empaneled manufacturers across the country who are eligible to bid, who manufactures those medicines that we have seen. Because Lordship will kindly appreciate.
No, Mr. Goswami, kindly see the subject.
It may right. This letter of intent is to the empaneled manufacturers.
This is subject to your quotation.
Yes, subject to my quotation.
So therefore, what do you quote?
I quote when a fresh NIT is issued, that is, I've not come to that stage. At this stage, no medicines quantity is quantified. Therefore, I have not even reached that stage. Once your empanel process is over, then the procurement process starts. The procurement process is started by an NIT. Please appreciate. And that NIT I'll come to. I have not reached this stage. I was just reading the clauses.
No, no, prior to that, kindly come to LOI, letter of intent.
Yes.
Your quotation against tender and all relevant corrigendum notices issued in this regard, reference. With reference to the above tender, we are pleased to empanel your company for entering into a framework agreement with AMCL for 3 years for supply of essential drugs as per specification detailed in the relevant annexure attached to this letter.
Yes.
Duration of the contract, this is it. Scope of the work and amount of year per item for per entire empanelment period, non-refundable is there. Delivery period, supply shall be commenced with best possible so and so. Now kindly come to B. For every procurement process, which is similar to what you read at 4, kindly see. For every procurement process, the empanel manufacturers will be asked to submit prices of the items.
Yes.
And purchase orders will be generated on the L1 rate. So the purchase orders will be issued in the ratio of 60 so and so, so and so, so and so, and this is what it is there, although the 5 lakh aspect is not there, or it's also there. So this, what you have mentioned in clause 4B Roman 2 is found in page 124. Okay.
These are extracts from the main mother agreement.
It's okay. Now you have the delivery period.
Yes.
On the basis of this L1 being found and it is being given to L2 and L3 at the L1 rate.
Yes.
And if the L2 and L3 do not agree, then they go to L4, L5, what may be. Then the delivery period will sell supply commence with best possible from time to day of the order, and supply of the full quantity shall be completed within 75 days from the date of issuance of the order. As on date, is there any doubt that there is an order being issued to you or not? So you have issued an order to supply within a period of 75 days.
That is where you have to understand that difference. That is what I was trying to tell you. Once the NIT, if Lordship will for a moment come to this document, please kindly come to my additional affidavit. And kindly come to page 231. Unless I explain this, I will not be able to. Please come to Annexure A1, page 231.
Yes.
Now, this is post empanelment.
Hmm.
This is post empanelment.
Yes.
This is an NIT, and here they indicate the medicines, indicate the tentative quantity, and tell the empanel manufacturers, please hold, please hold. What's that? Then kindly come to the next annexure is page 630. I, along with others, bid for certain medicines.
6-3?
638.
Yes.
I, along with other manufacturers, we bid for various different medicines. Some bid for ABC, I bid for XYZ. So this is my bid.
Yes.
Then lordships will come to A3, 641.
Yes.
Now we are on this 4 medicines,
Hmm.
which are for A641 lordships for ceftriaxone, iron L1. 642 for the next medicine, codrizamol, iron L1. For 643, glimepiride, I am L1, but I am at serial number 3.
643, you are L1. Yes.
But my name is at serial number 3 in this list. There are 2 other L1s along with it. And 644 is the 4th one. I am again L1. Now this is after the bid is open, this is what is prepared. Thereafter comes the rate contract. So after this is done, is now the rate, now I have given a rate, that rate is frozen. And once the rate is frozen, for that period, I cannot change the rate. But suppose it is like this, suppose for any of these medicines, I have quoted the next price and I have quoted for the entire tender quantity. It is not necessary for the tender authority to give me the entire quantity. That is very clear. So they give me a certain amount, suppose 50,000. They had initially invited a tender for 80,000 of X medicine, but they give me 50,000 to supply.
No, they give you as per the ratio.
Yes. Now the 50,000 may be ordered through one purchase order, maybe multiple purchase orders. But the contract is one. Please understand.
Hmm.
And that is precisely what has happened. That is precisely what has happened. So therefore, please come to my para 11 of my additional affidavit, because if I can cross-check with his documents, please come to, I have prepared this chart for your lordship's convenience. And these are data taken from them. What we have to now concentrate is on rate contract, not purchase orders. Now lordship will see the first medicine. I have also given the last 5 digits of the purchase order, which can be cross-checked. Ceftriaxone is broken down into 2 purchase orders. For one, 5,400, of which I have delivered 4,800 admittedly. And for the others, I was ordered 41,500, I delivered 41,500. So against this rate contract, 46,900 is the total ordered quantity, of which I have delivered 46,300. My percentage is 98.72. The mistake what they have done is this. They have taken out this percentage out of one purchase order, which cannot. What they have now trying to say is that out of this 4,800, you have
Out of 5,400, you have
delivered 4,800, so it is not 90. It's below 90. One purchase order is not one rate contract. Here, 2 purchase orders is the rate contract, and that is the language the blacklisting thing of the blacklisting clause also uses. Similarly, let's come to the next medicine purchase. These are the 2 purchase orders. Total, I was given 1,40,300. I delivered 1,39,600. 99.50 is my delivery percentage. And these are their figures. Similarly, Lordship, this is the. So the mistake now what has been made is this. You are overlooking the other purchase order, which constitutes very much the same purchase contract, rate contract.
So you mean to say, if I can put it in these words,
Yes.
once you get impaneled, for finding out as regards a particular supply of medicine required for a particular or 3, 4, 5 medicines, whatever it may be, a particular quantity of medicines of theirs, they'll issue a NIT. In pursuance to that, you have also quoted in respect to, as you could see, from 640 to 643 or 644, as regards 5 items, you in some cases L2 or L1, or most of the cases L1.
No, I'm just, we have bid for 25 basically. We have bid for 25. We have just given this 4 because these 4 are the subject matter of this list.
No, it's okay.
That's-
I'm on
Yeah.
24, I'm not on that. How many it is not the question out there. You are L1 out there. Against that, as per the clause 4 point Roman 2 or whatever may be, they are to give 65, 25, 11, 15. 65, 25, 15 or. And accordingly, they have given you 2 purchase orders in respect to all separate purchase orders
Of the same rate contract.
of the same rate contract. No, that I've understood. Because this is in pursuance to that NIT.
Which rise to.
Because one has to also understand, as per what you submit out here, that empanelment is a different aspect. There, for this period of 3 years, there might be 1 or 10 or 15 NITs also. But your concern is as regards each NIT. In this regard, against this NIT in question, which is the year, and more particularly these 4 items, you were given 60% work, purchase order. You have completed 98%, all this 90%, above 90% in respect to all this quantity. And if it is above 90%, the question of blacklisting does not come. That's your submission.
And if Lordship will now see the blacklisting clause itself, why I'm insisting on the word rate? It doesn't identify purchase order. Blacklisting clause itself also indicates rate contract.
Because the blacklisting clause says, if I remember correctly, taking up so many other matters, if you have less than 3 or less than 3, then it is, a blacklisting can happen if you have don't supply at all, 90% of the entire thing. But if it has more than 3,
If Lordship will come to page 60 straight
page 60,
of the writ.
maybe
That is
here,
very,
no?
very clear now. Page 60.
No, we are concerned with firm debarment, no?
Yeah. I'm just saying for text.
Yes, page
Next.
page 127, if you find it.
Page 60 is better, more legible. I may read.
Firms shall be blacklisted and debarred from participating in any tender by the TIA or procuring authority for 3 years if the company is debarred for all items where it has rate contract for less than 3 items, or at least 3 items where it holds RC contract for more than 3 years.
Here the question is, they have blacklisted us on the basis of purchase orders. That is not even one rate contract where they have debarred us. They cannot. So they went back to the purchase order, the small purchase order. If you see the impugned termination order, that indicates the 4 purchase orders.
But as regards product debarment, it does not say about rate contract.
Yeah.
Where is it? Kindly come to page
In
63.
case of- Page 60.
Yes.
In case of product department, in case of non-supply or incomplete supply, that is less than 90% of. the
Page
60 Lord,
signal.
of the writ petition. Product department.
Ah,
In case of non-supply or incomplete supply, that is less than 90% of the total ordered quantity by the approved manufacturer importer firm within the agreed delivery period, including the delay period, penalty period, or such extended delivery period, then the concerned rate contract
Shall
shall
be-
be cancelled. And the manufacturer importer shall be debarred from participating in any bid called by the authority for 5 years from the date of debarment of that item. So it's always rate contract.
and in case the manufacturer supply 90% or more,
Applicable at the most. In case the manufacturer importer supply 90% or more of the ordered quantity, but fails to supply the entire quantity within the allowed delivery period, then the firm shall be levied a penalty of at the rate of 10% the value of the short supplied item, and the same shall be adjusted against the payment for supply. That is all that they could have done.
and firm debarment, the firm shall be blacklisted and debarred from participating in any tender by the NIA or RIA if the company is debarred from all the items where it has a rate contract for less than 3 items,
And now
or
you,
at least 3 items where it holds a rate contract for more than 3 items. So you are more than 3 items.
not even one rate contract is not, not even one rate contract is cancelled.
No. You,
My not even one rate contract is cancelled. They cannot because all rate contracts are above 90%. I've shown the chart. So that is the problem they have made. And that will be evident from the termination, impugn blacklisting order. There could be more than one purchase orders in a rate contract.
so unless there is no cancellation of a rate contract, which is as per the product debarment,
That
you
is-
cannot come to clause 2.
that is- Now you see the impugn termination letter. Sorry, the blacklisting. And it is never purchase order based. And see what they've relied on. This comes straight to,
Where the impugn one?
it starts at page 210 and comes straight to, kindly come straight to page 213.
0.
213, these are the 4 purchase orders they've extracted. It is on these 4 purchase orders, which are not independent rate contracts, they have blacklisted.
So unless you don't have debarment,
It's obvious. Suppose a rate contract suppose a rate contract is for 10 pence. And you divide it into 2 purchase orders. In one, you give me 8 pence to supply, and in one, you give me 2 pence to supply. I supply those 8 pence, one purchase order over, in the next I supply 1. It'd be very absurd to say that we have only supplied 50%. Ignoring the remaining 8 that I've supplied. Because this whole 10 pence is one rate contract. So maybe out of those.
and the second aspect is without there being a cancellation of the rate contract, you cannot go for firm debarment.
They have relied on this 4 purchase order. They cannot cancel the rate contract because it's all about 90%. It is their own figures.
Now, do they issue a rate contract, or where is that rate contract?
Purchase order, that's the rate contract.
The purchase order is the rate contract.
They give it at that rate. 23.
So you being the L1, you automatically have a rate contract
Yes.
of 60%.
Rate. I only get the firm rate. I don't, there is no commitment of quantity. In a rate contract, there is never a commitment of quantity.
No, here if we see, they will give you, L1 will be given, and this page 53.
Yes.
Purchase orders will be issued in the ratio of 60, 25, 15.
Suppose give an indicative, suppose paracetamol. We want 1 lakh tablets. That is a tentative quantity. They may finally not purchase 1 lakh. So I have no claim that you promised me 1 lakh, so you have to buy, but you have to order me 65,000. Rate, the rate contract is only that I fix my rate, the quantity may vary. That is how rate contract would work. There is never the procurer.
Now, what do you say about 53, page 53, 4B3? Purchase orders will be issued in the ratio of 60, 25, and 15.
That
So-
was what they have.
No, therefore, why I'm saying it, if you put the purchase order as a rate contract, it becomes again difficult.
Rate contract is
No, therefore I asked you, do you have a separate rate contract, or is it on the basis that you are an L1 and by virtue of say 4B3, you are entitled to 60%?
is the rate for the expense. I've submitted my bid. That is my rate I have given to the purchaser. That this is my rate. And the rate contract is those 4 documents I've shown. L1 this price, L2 this price. That is the rate at which I've contracted. Please come back to that 4 documents.
No, that is at page 640 onwards.
Yes.
No, that I understand. No, that is understood. But where is it mentioned somewhere that or is it mentioned out there in the tender document which you have submitted? Because there was a tender for the purpose of procurement, as I could see from this particular page in enclosure. This one, kindly see the notice inviting tender dated 12/2/2025.
Yes, that's 231.
Yes, 231. Now, this must be the tender terms and conditions. Now, these tender terms and conditions here, is there any condition that the L1 automatically, or is it because of clause 4 or clause 4B3? Clause 4B3, therefore, in view of you being an L1 and you being an L1, you are automatically, you enter into an rate contract.
No. Yes, once
Yeah.
an L1, once an L1.
You are a rate contract for 60%. The purchase orders are for the implementation of the rate contract. I think that should be the proper thing.
Rate of one purchase of.
Maybe, whatever may be, but the overall the rate contract without being cancelled, you cannot go for firm debarment.
That is my comment.
So therefore, if I may again put it, you don't require a separate rate contract agreement. You're entering into the tender and being L1 automatically entitles you to 60%. It may not entitle the L2 and L3 automatically because they still have the option not to supply. Whereas L4 also, but for L1, it is there because by dint of 4B2. So you automatically have an operation of the term.
The clause.
Of the term. So you have a rate contract. And this rate contract has to be, by way of some order, has to be cancelled. And without their cancellation, you cannot go to the firm debarment. That is,
Which is not.
yes. You did not make this submission that day.
Yes, my lord. It is a new thing, my lord. No, no, for us, my lord. For us today, it's a new thing, my lord, because in this respect, my lord. Otherwise, my lord, in our affidavit, we have filed a affidavit, my lord. After issuance of the debarment notice, my lord, they have filed one representation, my lord. And wherein they have, this issue also, they have not raised there, my lord. Only they were trying to put that, my lord, they have completed more than 90% supply in respect of these three items.
But therefore, he is therefore saying,
Yes, my lord.
you see that the reason is this. Why is Mr. Goswami saying that we have submitted 90%?
Yes, my lord.
This is being said because if you take into consideration the supply which have been made for the rate contract for
Yes, madam.
that particular
Yes, my
thing,
lord. That is I am pointed out. My
it
point
is 90%.
Yes, madam.
Whereas if we see for each purchase order, one would be 100, the other would be 78.
Yes, my lord. My lord, but the 90% that they have represented in their representation dated 1911, my lord, after issuance of the debarment notice on 1711, there, my lord, they have not raised the issue of the two purchase order because they have actually, my lord, in our affidavit, I have stated that, my lord, in their representation, they have the quantity that they have supplied, my lord. They have taken it as a wrong quantity, my lord. They have pointed out a wrong quantity, my lord. It is in respect of only one purchase order, not two purchase order, because now they are saying that in respect of every item, there are more than one purchase order, two purchase orders. But in their representation also, my lord, they have pointed out only one purchase order where they have shown that they have supplied more than 90%, which is in fact not correct, my lord. Page 704, my lord.
70?
704, my lord. এটা continuing page. So debarment notice is at page, my lord, 700. So, and the items quoted are in the debarment notice is page 703, and they have replied at page 704, my lord. So, my lord, in respect of the item in their reply, my lord, glimparide tablet 704, my lord. In 704, they are showing that, my lord, supplied quantity is 40,000, quantity, ordered quantity is 43,500 and supplied quantity 43,500.
No, they come, maybe a white blue one.
Your lordship may come to page 704, my lord. 704, my lord, in respect of the item at serial number one, my lord, they are showing that they have completed the supply at 100%, my lord, which is not correct, my lord. And that I can point out from the MRC status, my lord. Lord. If you look.
Mr. Goswami, where are the purchase orders for these items
Yes.
at page 2 to 7?
Yes, it is, in fact, the whole, the chart is at page 680, whole chart.
At
Your
page,
Lordship, 688 is the entire data in one page, and the purchase orders are A4, A5, A3, sorry, A4, A5, A6, A7.
6,
645. If Lordship will see 688, we have got the convenience of the court. And these are all data from their website. 688. Annexure A. My friend can also have a look. This is the complete data. And Lordship can cross-check with the purchase orders.
this is whose document?
This we have made it on the basis of the 4 purchase orders, so that everything is in one page. In fact, supplied, if Lordship will see one. Eighth column. Supplied quantity as per MRP.
Now tell me why, I don't understand one thing.
Yeah,
Kindly come to 688,
yeah,
serial number 3,
serial number 3, okay, okay. Very good, okay.
985, 800, out of which you have supplied 960, 600. 43, 500, you have supplied 27500, isn't it? Now you kindly come to page 704.
4.
Why it's a different aspect being given here? Kindly
Yes, madam.
see.
704.
You say that you have already supplied 43,500.
Yes, my lord. Whereas 16,000 is remaining, my lord.
It's with respect to Glenwood Prime.
Huh?
Let us see the document, please come to 688.
No, this is your document.
No, this
Yours.
is, I prepared, I said. This is a document I have prepared on the basis of the original document, which is also on record.
No. Kindly come to 704 of the affidavit. This is your statement.
$43,500. Supply 100%.
You have supplied 43,500. Whereas if you see at page 68, this is the document which you say, as on the so and so, is you have supplied 27,500. As regards this 43,500. Why this discrepancy?
This is right. We will go by this one. And
Then
actually,
what is this
this is
representation?
our statement. This could be, no. We are now admitting that there is a short supply. We are saying that this is to show, this was our claim that we have supplied 100%. Now there was a bona fide dispute. They said the last portion we will not agree. Last time, what they said, they opposed that. So now we are saying, okay, we are going by your records only, your MRC records only. And your, in fact, relying on your MRC records only, we are above 90%. And those MRC records also we have. Please come to, Lordship, if this is limit right, please come to the limit right A6, page 668. 668. These are all the documents pertaining to this limit right chapter. First is the purchase order, Lordship. 43,500. Lordship has seen that.
Yes.
Then Lordship will turn over. These are the places where we have to supply 670. Now this is their MRC. Lordship can add.
Yes.
Add for
670 is the MRP.
671.
Yes.
This is their MRC.
Uh.
671.
And then
Then the next purchase order of the same medicine is at
how much is the total of this? Accepted supplied quantity.
and this is all yes.
So this is the total comes to around 27,000.
This is their data.
This is all supplied.
Yes.
100%. Accepted is less or something. What is there?
No, accepted is exactly the same.
Then why there's a, if this is the ordered quantity and supplied quantity, then how there is a difference out there again?
Pardon?
How there is a difference of 27,000 as you say? No, this is for the 43,000. Are you not saying that? You see, the purchase order kindly come to 668. 1/3/2025.
Not, this doesn't add up to 43,000.
No, it's okay. This is for 43,500.
It doesn't add up to 43,000.
So this is different.
And the other purchase order is the 99 lakhs 85,800.
Here also it is being done total.
Yes.
There is no difference. So these are the two purchase orders which you are referring to.
To one.
Give me price. So here, therefore, I'm asking you if this is the MRC. If this is the MRC for 668 purchase order of 43,500,
I'll just tell you, it doesn't add up. 671 is 27,500.
this is 27,500, na?
671.
Okay. So therefore you have only, but why you are saying ordered as only this much? Why it is mentioned as ordered quantity less? You see, in the MRC status, ordered, supplied, accepted.
Yes.
You see, ordered is 43,000. There is no breakup.
Yeah.
As per the purchase order, there is no breakup. But why there is a difference of ordered, supplied, and accepted?
Places, right? See the first thing. Kamrup Metro, Bhima Assaw.
Okay, so therefore they given. Okay.
These are the items that will be supplied to different places.
Okay, so therefore these are the different things where you are to supply and
Yes.
accordingly you have supplied
Yes.
this. In some other places you have not supplied, maybe. No, okay. And in the other one, you have 98,500 and 9 lakhs 85,500, 85,800. You have already supplied the entire one, na? The total of 675 and 676 is 9 lakh 60,000,
Yes.
isn't it?
Yes.
9 lakh 60,000. There is a
3,600.
600, but you have not supplied some less.
The total comes to 25. So the total percentage comes to 96% of supply. In fact, this in actual A chart is when we have summarized it.
Okay, now, yes, tell me.
Because my lord, as per the notice, they have, in terms of the notice, they have submitted this representation at page 704.
Forget about the representation.
Yes, my lord.
Come to the point. You
Yes.
see, once a person is empaneled,
Yes, my lord.
he has a right to participate in the tender. Because if you see the tender at 230, is only for those empaneled participants. Accordingly, he participated in various bids, may have been. We are concerned with these 4 drugs.
Right.
Of these 4 drugs, he have been the L1. Becoming L1, by virtue of your letter of intent as well as also clause 4B2, he has a right of supply to the extent of 60%, being the L1.
Yes, madam.
That's a right. Whereas L2 and L3 has a right of 25 and 15, but he can very well say that I'm not going to supply. Then it may go to L4. Now, pursuant thereto, admittedly, you have issued not one procurement order, you have issued 2 purchase orders. No quarrel in respect to these. But a contract is one. Contract is in pursuance to, that is the contract which is, can be seen from 5D, page 53. One contract. It may be, if you have 10 tenders, there might be 10 contracts, rate contracts. But here, the contract is fixed that for Glimmage Pride or whatever may be, it is 0.13 paisa per piece. So this is the price. It is fixed. Unless you cancel this contract, how can you go to debarment, firm debarment? My question is that.
My lord, as per clause H, my lord, at page 60, my lord. So, my lord, the authority has gone by the clause in view of the fact that, my lord, when there would have been default in respect of one item, then product debarment proceeding would have been initiated. Now, since his default is in respect of more than 3 items, that's why, my lord, the clause 2 proceeding has been started. Firm debarment.
No.
Yes, my
That is,
lord.
I understand. Let us come again to page 60.
Yes, my lord.
You see, product debarment, what happens? In case of non-supply or incomplete supply that is less than 90% of the total ordered quantity
Yes, my lord. That is
by the approved manufacturer importer within the agreed delivery period, including the delay penalty period or such extended delivery period, then the concerned rate contract shall be cancelled.
yes, my lord.
Where have you cancelled that?
That will be when there will be default in respect of one item. When there is default in respect of more than one item, my lord, then the clause 2 will follow, my lord.
First, you have to cancel the rate contract. Have you cancelled the rate contract? First question is that. No. The answer is no. Now, further, let us go. Shall be cancelled, and the manufacturer importer shall be debarred from participating in any bid called by the authority for 5 years from the date of debarment for that item.
Yes, my lord.
So, therefore, this is the product debarment after cancellation of the rate contract. Okay.
Yes, my lord. And
In case the manufacturer importer supply 90% or more of the ordered quantity, but fails to supply the entire quantity within the allowed delivery period, then the firm shall be levied a penalty of 10% of the value of the short supply item and same shall be adjusted against the payment for supply. Okay. So if it is less than 90%, more than if he has already supplied 90%, then you may impose a 10%. And further, you have also the option for going for alternative supply purchase at the risk and cost of the supplier.
yes,
That is also there.
yes, my lord.
Firm debarment, it comes as the firm shall be blacklisted and debarred from participating in any tender by the NIA, TIA, or the procuring agency for 3 years if the company is debarred for all the 3 items where it has rate contract for less than 3 items, or at least 3 items where it holds rate contract for more than equal to 3 items. Where have you done that? This is his specific argument.
Yes, my lord.
It's an argument on a point of law on the basis of the contract. So we dictate.
Yes, my lord. So they have proceeded with the clause 2 only.
You cannot go to clause 2 without following clause 1. And it is a rate contract.
Yes, my lord.
You see, you have to understand, it is not normally any other contract where if it is, first is empaneled.
Yes, my lord.
That is why I asked Mr. Goswami, how do you get empaneled? There must have been some procedure, but the fact remains that he is empaneled by the letter of intent. Once he is impaneled, then he has a right to participate. He participated, and in pursuance to this participation, yes, there has been a delay. No quarrel, there is a delay of some of the items he has not supplied. You have given various opportunities. But for that, you need to cancel the rate contract.
In respect of individual items.
If it is done more than, if there is a delay of more than, yeah. Because the ordered quantity as per the rate contract is 60% again, you see.
Yes.
60% of the total quantity. Let us see the NIT. NIT has given, in this NIT, what is the quantity required is given. Let us see the Glimmage paid or what is that? Which is the most easier thing to find out. Yes. How many grams is yours? Tablet, Glimepiride? 1 mg. They require 41,36,700. Isn't it? Packaging item total quantity will not be applicable to here. The consignment to be delivered centrally at Guwahati will not be applicable. So here, for this particular at 237, is 41,000. This is the quantity which is required, of which you have placed an order upon him by 2 purchase orders. You can further go ahead. It's a different thing. It may be at a later point of time, it may be more. You can very well again debar him, whatever it may be. But first you have to find out that whether it is 90%. As of now, it is not 90%. You can't have it individually against the purchase order. Against the rate contract has to be cancelled.
Yes, madam.
We dictate.
An individual cancellation order has to be also issued, madam, in respect of individual cancellation order in respect of every item.
No. What the rate contract is, you have to say that you being an L1,
Yes, madam.
you have an L1.
Yes,
You
that is
tendered
one
this
point.
quantity.
That is one point.
You have failed to supply.
Yes,
In spite of this, whatever failed. So therefore we cancel it.
yes,
And if it is more than 3 items,
yes, madam. That
you
is
see,
there.
if it is more than 3, if the rate contract which is given,
Then
because just for example, this tender had as many as 424 items.
yes, madam.
He had quoted for 5 items. Example. He is the L1 for these 5 items. So he has a rate contract as regards this. If in that case, if he fails to supply in 3 items, less than 90%, then only it can happen as regards the firm debarment.
Yes, madam.
If it is, he has the rate contract, he has a rate contract on the basis of only 3 items or less, and he fails to supply that,
Yes, madam.
then you have to cancel that contract.
Yes,
That you have misled us to become an L1 and you have no intention to do so.
yes,
Because that must have been done with a basic reason. Just for example, let us take example of another medicine supplier. He quotes an abnormally low rate. He may quote,
yes,
and therefore he doesn't supply. Thereby, it becomes such a position that the L2 and L3, therefore option is given to L2 and L3.
yes, madam.
L1 is not given an option, see, isn't it? L1 is not given an option, as you can see. L2 and L3 can say that, okay, I won't supply at L1. It may go to L4, it may go to L5. L1 is not being given because if he doesn't supply, there might be a question where they may have to reconsider the rate. Hello, dictation.
But only one thing, my lord, because in respect of the other 4 purchase order, because he has shown 8 purchase orders. And we have filed the affidavit quoting in respect of only 4 purchase order. But other 4 purchase orders, the MRC status, I am not aware, my lord. Whatever they have put in page 688. So that is, I don't know, my lord, whether that is correct or not.
No. That document which he has put it,
Yes.
MRCs,
Yes, my
this affidavit was very much there
yes, my lord.
on filed on 5th.
Yes, my lord.
One.
That is in respect of only 4 purchase orders.
No, he has in this additional affidavit put both the affidavits. Kindly see this.
Yes.
All the 8 purchase orders.
Kindly come to
No, I
600
understand. What I am submitting, my lord, I have placed before this honorable court the data MRC status in respect of 4 purchase orders that was pointed out earlier. But
No.
in respect of other 4 purchase orders, in respect of he has claimed that he has completed 100%, my lord.
Hmm.
That data, I am not sure, my lord. That is my submission. Because the data in respect of only 4 purchase orders we have placed by way of this affidavit. But in respect of other 4 purchase order, in respect of whom the petitioner has claimed to have completed more than about 100% supply, my lord. That data I have not verified or I don't know, my lord.
Suffer the consequences if you put something wrong.
Yes, ma'am, I understand.
Will suffer the consequences if you put something wrong, you go to court.
How will we know then?
They will verify. They
If
said
that is the verified, the matter cannot be disposed of.
They don't still believe in their own documents. Time and again, I'm saying these are data, their data. You have downloaded from their website.
What is page 689?
689.
Yeah.
These are the summary of the purchase orders I have got. Over and above these 4. Pertaining to the same tender.
This has been given to you.
Yes. These are the other purchase orders. This is just a summary here.
What do you want now?
It's up to your lordship. I am just pointing out that only that is the only point, my lord. On their basis, my lord, that may be verified by the authority also, my lord. If in total, as your lordship has indicated, by collectively, my lord, in respect of the 2 purchase, because the debarment notice apparently has been issued on the basis of 1 purchase order. So in total, if it is more than 90%, then that your lordship may indicate, my lord.
Mr. Goswami, this thing which is there, this just for example 676, 5 and 676, this is a document of them, na? MRC status. Page 675.
675, yes, sir.
So this is their data, na? So this you got it on 212. 212. So before, so this particular data which is there, just for example, in all others you have supply. So here there is a less of around 25,000 at 676.
All that we have consolidated in annexure 8.
Chalo.
Everything is consolidated. But in that electorate, we have put in purchase order wise, so that it immediately correlate.
Heard Mr. M. Goswami, the learned senior counsel, assisted by Mr. R. Sinha, the learned counsel appearing on behalf of the petitioner, and Mr. D.P. Bora, the learned standing counsel of the Health Department, who also appears on behalf of the respondent numbers.
All the
The-
respondents.
who appears on behalf, also on behalf of the Assam Medical Services Corporation Limited and its functionaries. The AI appears on behalf of all the respondents. First, the present petition has been filed by the petitioner challenging the debarment notice bearing number 588-121/20193 dated 17/11/2025, whereby the respondent authorities, whereby the respondent number 4, na? This is done by respondent number 4. Whereby the respondent number 4 have debarred have blacklisted and debarred the petitioner from participating in any tender for 3 years from the date of issuance of the said letter in terms with clause 5, subclause H, capital H, PT number NO bracket Roman 2, PT dot NO bracket Roman 3 and subclause M dash subclause dash M for default in supply of 4 numbers of essential drugs against 4 numbers of purchase orders, the details of which have been placed in Annexure A to the said order, said order dated 17/11/2025. Bracketed there, hereinafter referred to as the impugned order. The question which arises in the instant case is as to whether this court, in exercise of the powers under Article 2 to 6 of the Constitution, is required, is as to whether the impugned order dated 17/11/2025 calls for any interference in exercise of the powers under Article 2 to 6 of the Constitution. Take a seat. In order to adjudicate the said aspect, this court finds it pertinent to take note of certain relevant facts which led to the filing of the present petition. First, the respondent number 4 had issued a notice inviting tender inviting online bids for empanelment of manufacturers for the supply of essential drugs to various health facilities under the Department of Health and Family Welfare, Government of Assam, by entering into a framework agreement valid for a period of 3 years. The said agreement dated date to deliver, huh? On 10/2/2023. For the purpose of deciding for the purpose of adjudication of the instant dispute, this court finds it relevant to take note of some of the clauses of the said bid document. Clause 4 of the bid document refers to is with the heading evaluation, selection and acceptance of tender. Capital subclause capital B of clause 4 of the bid document refers to bid evaluation. Subclause B of clause 4 being relevant is reproduced hereunder, page 53. A perusal of the above quoted clause would reveal that in terms with clause 4B bracket 1, the tenders so submitted for evaluation for empanelment would be evaluated with reference to technical and commercial parameters to determine the technically empaneled bidders for all items. It further stipulates the requirement of entering into a contract with the empaneled bidders, which would be valid for a period of 3 years, with an option to further extend the period for another 1 year. Subclause clause 4B bracket Roman 2 further stipulates that after conclusion of the empanelment process, a separate process would be followed to discover the lowest price against a particular item amongst the empaneled bidders. The process of price discovery will be initiated against every proposed procurement. Clause 4B Roman 3 further stipulates as to how the purchase orders would be issued. From a very perusal of the said clause, it reveals that L1 bidder has a right to claim 60% of the supply of the supply of the medicine, of the drugs in question. Whereas L2 and L3 bidders either have to match the L1 rate, and if not, the authority concerned would offer the lowest bid, offer the bid or offer for supply to the next lowest bidder. This court further finds it relevant to take note of clause 5, capital D. Of the bid document. As inasmuch as the same said provision throws light as regards the formation of a rate contract. The said clause 5D being relevant is reproduced herein under page 57, 58 of the Clause 5G refers to delivery shortage and delivery delay penalty. Mr. Das, you had an unlisted matter today. Okay, let us take your unlisted for the time being. Your matter is urgent. Does not come.
Another 10 minutes is coming.
Huh?
They have found out some defect. So it has been rectified, is coming under them. Your lordship may take it tomorrow also.
Today it is coming.
10 minutes. 10 minutes time is coming.
Huh? I'm here till 4:40.
My lord, that copy I have received at about 2 p.m. only. Even I could not go through the copy.
It's a supply orders, my lord. My lord, it has been, they have been blacklisted and they,
Who?
the medical. I think it is more or less similar, I think, to this.
I could not go through the copy. Just at
Let
about
them go through it. Blacklisted anyways. I don't pass a first day in time order. Get it tomorrow.
Will it be taken tomorrow, my lord, or we'll wait if your lordship.
Don't wait. He is not ready, na?
yes.
I'll list the matter tomorrow. Because I have to rise at 4:40, na? Because we have a full court.
I'm deeply obliged. Ready to.
Clause 5G refers to delivery, shortage and delay penalty. Clause 5H stipulates debarment / blacklisting for failure in execution of supply / non-supply / default in supply. Taking into account that the respondent authorities While the impugned order had blacklisted the petitioner, comma, Clause 5H Roman 1 and Clause 5H Roman 2 assumes importance. And as such, the said two clauses are reproduced herein under page 60. A perusal of the above quoted clause reveals that in case of non-supply or incomplete supply, less than 90% of the total ordered quantity by the approved manufacturer oblique importer within the agreed delivery period, including the delay penalty period or any such extended delivery period, then the concerned rate contract shall be cancelled and the manufacturer oblique importer shall be debarred for participating in any bid by the authority for 5 years from the date of debarment for that item. However, in the case if there is non-supply or delay in supply, there is however, in the case of incomplete supply of 90, incomplete supply, however, in the case where 90 or above or more of the ordered quantity have been supplied by the firm, by the manufacturer oblique importer firm, a penalty of 10% would be levied of the value of the short supplied item, and the same shall be adjusted against the payment for supply. First, the firm debarment is individualized in clause 5H Roman 2. From participating in any tender by the tender inviting authority or the procuring agency for 3 years, if the company is debarred from all the items, bracket, where it has a RC contract, RC rate contract for less than 3 items, or at least 3 items, bracket, where it holds RC contract for more than equal to 3 items. A conjoint reading of clause 5H Roman 1 and clause 5H Roman 2 would show that there is a requisite for cancellation of the rate contract prior to taking steps for product debarment as well as firm debarment. In the backdrop of the above, let this court now take up the facts involved. The petitioner, along with various other bidders, duly participated in the said empanelment process, the empanelment tender, the tender for empanelment issued on 9/2/2023. On 28/7/2023, the petitioner, along with 184 other companies and firms, were empaneled for 3 years for supply of essential drugs as per specifications detailed out in the annexure enclosed to the said letter of intent. The said letter of intent also includes various provisions which are akin to the bid document pertaining to the empanelment bid document of the tender dated 9/2/2023. The record further reveals that after the empanelment proceedings was over, by issuance of the letter of intent and entering into agreements, empanelment agreements, with various entities, a notice inviting tender was issued on 12/2/2025. By the respondent number 4 on behalf of the respondent number 2. Amongst thereby inviting amongst the empaneled suppliers for submission of bids as regards the items as well as the respective quantities to be supplied. The petitioner, being an empaneled contract bidder, being empaneled, submitted its bid. And taking into account that the present writ petition is in respect to non-supply of 4 essential medicines, oblique drugs, that is, number 1, CEFTRIA ZONE powder for injection 250 mg, vial. CO dash to page 64, 641, 642, 643, 644. এই 4টা আইটেমটো ওপৰত লেখা আছে নহয়, ওপৰত এই নামকেইটা দি দিব। So and so, so and so, so and so, so and so. it is pertinent to observe that the petitioner in all these four items was the L1 bidder. The materials on record reveal that against each of the above four items, essential drugs, the petitioner was issued 2 purchase orders each. Which would be evident from annexure A4, A5, A6, and A7 to the additional affidavit. Full stop. Before further dealing, before further, full stop. At this stage, this court finds it very pertinent to observe that in the notice inviting tender dated 12/2/2025, it has been categorically mentioned at NB3 that the quantity indicated in the said notice inviting tender is tentative only, and purchase order will be placed in phase-wise manner as and when required. তাৰপিছত লিখিব, the petitioner has been issued purchase order in respect to these 4 items, which have been enclosed as annexure A4, A5, A6, A7. Huh? It is the case of the petitioner that in respect to these 4 items, the petitioner being the L1 bidder a rate contract fixing a particular rate in respect to supply of the various medicines, including the essential supply of various essential drugs, including these 4 essential drugs, have been entered into. as would very much appear from a reading of clause 5D of the bid document. The purchase orders which are issued in pursuance thereto are towards the implementation of the contract, towards the implementation, are towards procurement of supply as per the rate contract which have resulted pursuant to the submission of the bid by the petitioner, more particularly in respect to the 4 items. It is therefore the case of the petitioner that till any supply is required to be made in terms with the tender, in terms with the rate contract formed on the basis of the tender dated 12/2/2025. All the purchase orders against each item, against each rate contract, have to be taken up together for ascertaining the amount of supply so made by the petitioner, or for the matter, the bidder. At paragraph 11 of the additional affidavit, the petitioner had provided that against the 4 items, 4 essential drugs, the petitioner have been issued 2 purchase orders each. And each for each essential drug. And the supply so made by the petitioner is far more than the 90%. At paragraph 11 of the said additional affidavit, a chart has been provided. Taking into account its relevance, the same is reproduced hereunder, page 227. Next. The records further reveal that against 4 purchase orders, the petitioner, in spite of being granted opportunity, have failed to supply the entire quantity, or for that matter, have supplied have, or for that matter, have supplied less than 90%. Under such circumstances, a show cause notice was issued. Under such circumstances, a show cause notice was issued. On 26/8/2025, as to why the petitioner, panel actions for blacklisting or debarment against the petitioner should not be taken. Huh? Why?
Half the flights are on 14 months. Whatever seat I could.
You are leaving today? Okay. Anyways,
I'm extremely sorry.
no, it's okay. No, anyways, I will get the order by tomorrow. You will get the order after 2 days because of the fact that I'll dictate it after take some time for typing it out, and then by tomorrow, by Saturday, I think it will be uploaded. We'll quash it. This one will quash this.
Happy.
You will make.
Pleasure addressing the doctors, but please excuse my presence.
Huh?
Please excuse my presence.
Yes, please, please.
So,
Thank you. On 26/8/2025, the petitioner thereupon submitted reply on 27/8/2025. Be that as it may, there were various further extensions being granted to the petitioner to make the supply of the remaining quantity. However, as the petitioner failed to supply the impugned firm debarment notice was issued on 17/11/2025. To the said firm debarment notice dated 17/11/2025, specific reference has been made at Annexure A to the impugned communication. To the purchase orders and to the extent to which the petitioner had supplied against those purchase orders. The details in Annexure A to the said impugned notice appears the details of Annexure A to the said impugned notice. And I like, oh, stop. Petitioner being aggrieved approached this court by filing the present writ petition. This court, by an order dated 28/11/2025, issued notice thereby directing the respondent authorities to bring on record their stand so that an attempt can be made to dispose of the writ petition on or before the next date, on the next date. That is today. It is seen that the respondents have duly filed their affidavit in opposition. In addition to that, the petitioner had also filed the additional affidavit on 5/12/2025. The stand of the respondent authorities in the affidavit in opposition is specific to the extent that the petitioner did not complete 90% of the supply against each of the 4 purchase orders, reference which have been made at Annexure A to the impugned communication dated 17/11/2025. It is further mentioned that the delay in supplying have resulted in providing has affected the supply of essential drugs to the government hospitals. And as such, the hospitals. Okay, remaining I'll give it.
Yes, madam.
I'll set aside this. Huh? Good thing done. Any other matters? Have matter to aise niki? Mosul to aise. This is the matter tomorrow. Yes, Mr. Samoa. Let us take your chance with your matter.
Well, item 12 and 13.
When do you want it? Obviously after vacation. Now no time. When? 1 month, 2 months, 3 months, 6 months? Okay.
As per your.
Give me the reason why you were making a submission in the morning.
Actually, while the first repetition.
What was the writ petition filed for?
Been appointed as a peon. Gave the object, complaint is that he is overqualified. He had passed the RSP. Actually, according to the rules, he should not have passed, he should not have passed the RSP. That is the complaint. So against that, there is an inquiry ordered by this court.
What is there? These type of matters I've finished it off all.
No, Miller,
Why inquiry is required?
because he has already been.
All other matters we have already said that this is absolutely, when you have come before the court fraudulently, you are not entitled to anything.
No,
It's a
Miller,
fraud
during
case.
the inquiry, it has not been proved that-
Not inquiry, the inquiry we dispense with, which set aside your appointment. Are you denying that you are not overqualified?
Submit this.
I'm asking you, are you denying that you are not overqualified?
He stated he appeared in the examination.
But he didn't know that he passed out. No, understood, that happens. That is why did he appear in the examination? But you have passed out. On facts, it is passed out. You may not know, but you have passed out. Understood, but the fact that you have passed out is not in doubt. So are you saying, are you denying?
In inquiry, the departmental authority called for the records from SEBA, called from the record from examination center, called from the record from the college. No, they got certain records, but there is nothing to say that this is the person who passed.
Mr. Das, what is this matter?
And item 12, my lord. In item 12,
Now, how is it that, first of all, why did you initiate a departmental inquiry if you don't have a document that he has passed class 12?
But so far as I know, this is the case of overqualification.
Understood. He says, Mr. Samoa says, then look here, I don't know, I passed.
He don't know, he doesn't know.
That I passed.
Fine.
And you have not been able also to prove that
That
he
he
has
passed.
passed.
That is why I said that let the inquiry report come.
Not
My
inquiry.
instruction-
Inquiry is not required. If we have the certificate, we finish it off.
Yes, my lord.
I've delivered many judgments. What inquiry? These type of inquiries are not
In
required.
fact, my lord, there is no requirement of any holding any inquiry, but
No.
they have decided to hold an inquiry. It's fine. It's their wisdom. But the thing is that it's,
Is there a stay order?
no, my lord.
Okay, you finish the inquiry. Ask the,
Today, my instruction is that today the order of the disciplinary authority will come.
very well.
Today.
We'll have it after vacation.
Fine, my lord.
Finish all. List the matter on 29th.
Good.
What is the other? Regularization is another concept from, this has nothing to do with it.
Subject matters are different.
Then?
This is different.
Why 12 has no business? Okay, 12 also regularization. This is only the date 29th. 29th. Okay.
Fine, fine.
January.
Yeah.
Yes. Yes. You have no urgency.
But I am, for the other side, I have to appear.
What matter? You have got an interim? Okay, we pass an interim.
They would, what they would pay, what they would pay.
Oh, that one. Huh.
So
What?
I have nothing to do.
You have
you
nothing
take
to
this.
do. Yes, when are you paying? No, not 3 lakhs. No, this is no bargaining business. This, do you think this that's, do you get, you see, any smell of any fish out here? Huh? We make it 5 then. We
I have
dismiss
the
your
bank
case
details
only.
with me.
Huh?
I have got his bank details, etc.
You got it?
Yes, I
Chalo.
sent a letter. Eventually, he responded when I said the honorable.
Tomorrow at 2.
Obliged, Lordship.
5 lakhs now. Either agree to 3 or 5.
I have nothing to say.
No, he's unnecessary. Means you can't bargain. I've thought about it and given it 3 lakhs. And very conservative is the 3 lakhs. What do you say? That the argument you can make.
In the other case where I appealed for the petitioner for the paper matter, I was not there. I was in Jorhat. My Lordship had fixed 3 lakhs for each person for 8%.
8%.
24 lakhs gone. No, I. Yeah, other
But
side,
therefore, he doesn't want to say that it should be more because that matter is also pending next
No,
week.
it's over. It's
Huh?
over. It's over at 3.
3, they have done, na?
3 into 8.
Arre,
I know.
I got you at 3 when their claim was 9.
Yes.
There? The moment they were saying otherwise, I told them that okay, 3 you give it. They were saying about 1. Same thing, he was also trying to act fish out here in the court. So nothing doing. 3 you agree, otherwise dismiss. 3. Tomorrow,
Tomorrow at
2
2
o'clock.
Obliged.